Okay, good morning. We're going to start shortly. Before we start with a bit of a technical announcement. So you all have received an email with a Zoom link, which you need to connect, even if you are on site, to present, to share your slides from your computer the way I do now, right? The Zoom should work. If for any reason it doesn't work, like try to reach me at some point so that we can load your slides on the presentation of the computer. In principle, we try to make it easier so you can present from your own machine, but if you can't, just reach out and to me or Nikos who are here, and we'll try to load your slides on the computer. Okay, other than that, I think we are ready to start with only 6-minute delay. So welcome everybody to the 7th version of the Natural Language Processing workshop. And yeah, good morning from what seems to be a very rainy and gloomy Suzhou. I think we have people connecting at least from the US and India, and later also from Europe, depending on time zone. So welcome everybody. It's the 7th run of the workshop, and I'm very happy to uh, welcome you all. I am Jeris Panakis, one of the organizers from Maastricht University, and in the organization team, I'm joined by Nikos Aletras, who is also here, Leslie Barrett from Bloomberg Law, and Daniel Pretwich from Bloomberg, who are online, and Ilias Chalkidis from University of Copenhagen, and Catalina Guanza from Utrecht University, who, based on their Europe time zone, probably will join us a bit later. So, I have some, I tried to put some news from where, things with legal tech are going wrong, and there are, too many of them. And probably you also know more of these. So it's just an indication of, the field is blooming and it's becoming more and more relevant for us to work in this field. And it's not just perhaps, robot lawyers, AI-generated citations and stuff. It's also all the new legislation which is popping up around the AI Act or the Digital Services Act. So my point where I'm getting with this is that there is always a legal angle, and which is also the aim of the workshop, to bring together people from the NLP community, the broader machine learning community, and the law, and foster collaboration in these areas. The theme of this year's EMNLP was, because it's in the past EMNLP, was interdisciplinarity. I think we are very happy as organizers that, we always were interdisciplinary, and we aim to be interdisciplinary and build bridges between disciplines like law and natural language processing, which traditionally also maybe weren't talking to each other. And exactly these are some of the goals of the workshop: to identify also future directions and priorities for computational approaches to law, and also domain-specific challenges in the legal context. So this year also we revamped the call for papers to reflect not only past submission trends, but also the changing needs, let's say, of the community. And we procured papers in all these areas. So, of course, applications of NLP to legal tasks. Legal judgment prediction has been for many years one of the leading themes. And as I mentioned later, this year we don't have no paper on legal judgment prediction, just because people have evolved and moved on to things like legal argumentation and reasoning, summarization, contract drafting, and also things like copyright and IP law, legal misinformation, all tasks applying NLP to the legal domain. Also, we're not behind the other NLPers. We apply LLMs to the legal domain with all the range of techniques: prompting, chain of thought, privacy bias, and different copyright risks. There's also methodological innovations to legal tasks. This year we have papers on graph models and also agents as a new direction. Of course, new data sets, new languages, new jurisdictions, resources and evaluation in the legal domain. Something which is also quite exciting is applying NLP for online platforms, social media, and also all the new regulations. We talk about illegal content online. There have been many papers about in the main conference as well about, hate speech, but what is hate speech legally speaking. Also, the Digital Services Act, AI Act, Digital Market Acts, Platform Terms of Services. These are topics that fall under the umbrella of the workshop. We also ask for systems, demos, and industry applications. And of course, in disciplinary position papers discussing ethical, legal, or regulatory aspects of applying NLP to the legal domain. Topics like access to justice and what does it mean, plus also platform governance and moderation, how it should be done. That being said, we got some numbers. Everybody likes them. 71 direct submissions through open review, out of which 29 were accepted. That includes also rejected papers due to relevance and anything. We didn't aim for a particularly low acceptance rate in that sense. We also accept papers from the ARR cycles. So there were 7 commitments there, out of which we accepted 3. They're all published at the workshop either as full or non-archival papers based on what the authors preferred. And also we asked the authors of findings papers, which usually were packed in the lunch sessions, if they want to get a slot here to present, and 5 of them accepted and will be presenting with us today. As I said, something about the submission trends, which is something that, I made the last days. As I said, there is a shift in the focus on LLMs for legal reasoning and evaluation. And we interpret it as shifting from legal judgment prediction to, and maybe how do we, if you can use LLMs in law, to more tailored questions, like how well do they reason legally, and also under what conditions they do it, or under what conditions they fail. Retrieval as a task and also summarization, they gain more and more traction, also in specific applications. And of course, right now that we have LLMs and we can throw them on every task, many of the authors explore benchmarks and how we can do robust evaluation, coming up with new frameworks and finding gaps in evaluation, which are maybe how the traditional legal NLP has evolved. At the same time, we have, I would say, for me at least, exciting new legal NLP tasks, which we're going to see later on, like, for example, trademark scale construction tasks or use of voice in court settings, legal procedure simulations, or consumer markets, and so on. These are things that maybe we haven't seen traditionally in the past. And also niche but critical applications, like discussing the socio-legal impact of some of the technologies, also governance, and also the very interesting angle of compliance and enforcement of regulations online, like in social media and platforms in general. And of course, as an overarching theme, we keep seeing also, I guess, in par with the main ACL and NLP conferences, also multilinguality, multiple languages, like law is inherent multilingual, and also new data sets. I think in this run of the workshop, we have papers in Thai, Korean, Chinese, Portuguese as well. If I remember from the submissions, we also had even more languages there. Okay, so this is the program committee. Don't worry, I'm not going to read all the names because there are too many, and I think some of you are also here. It's a 3-page list. Sorry, 2-page list, but around, I think, 65 members. What I would like to say is that, first of all, thank them for their work. Thank you for your work. And also mention that each direct submission paper received 3 reviews, And in the context of the workshop and the disciplinarity we aim for, one is always a legal reviewer, or at least we aim for a legal reviewer, to which they have a different perspective. That's why also, reviews are diverse in that sense, which we try to synthesize in the decision-making process. So thank you for your work, and we hope you can join us also in the next iterations of the workshop. So the workshop is being live streamed on YouTube as we speak. I guess we're not going to go viral unless something, amazing happens. I mean, something amazing will happen, but maybe it doesn't make us viral. And we have a YouTube channel that all the recordings will be available afterwards. There is a Zoom direct link which you can use. It's also in the email we send around with the instructions if you ever need to find it. I guess you can also go back to the YouTube and see it here, because if you are watching this, it means that you are already connected. The proceedings are already available. This is a QR code which should work and take you directly to the proceedings if you want to check them now in parallel with the presentations. Speaking about materials, the YouTube channel is there, and it has past editions of the workshop if you want to binge 9-hour talks on legal NLP. Also some past NLP talks that we have been conducting. And as I said, we are live now as we speak, so the recording will be available afterwards if you want to watch yourselves or if you want to share it with colleagues. We are also on some popular social media platforms. That includes X and Blue Sky. These are the hashtags we're going to be using: NLLP, MNLP25, Legal Tech, NLProc. The handles are the same both in Twitter and Blue Sky. If you post, we'll also, amplify them, try to boost them further. Feel free also to post your own content and either now or later. More things, organizational things, is that we do have a Slack channel just to keep in contact with each other. As I said, we aim to have community, be able to reach out to each other, find collaborators, also find collaborators maybe from the legal domain, which might be difficult. If you are not there, I know some of you are, just join as well. Another QR code, different this time. There's also a Google Groups mailing list, which we send announcements. Slack is a bit more interactive. Of course, the website, I think you all visited at least once before this workshop. And we also have a LinkedIn group a bit under construction for quite some time now. But yeah, we are trying to reach out and keep contact between each other with all available ways. Okay, we do have sponsorships. So we do have a big sponsorship from Bloomberg on the Best Presentation Award, which comes with a $500 prize. That will be announced at the end of the workshop, so it's also a motivation for you to stay. Apart from the award, there's also a nice certificate, which I need to procure from the ACL office. There were some delays there, but you get the certificate, the picture, and the $500. Not today. We'll do the transfer later on. So that's a motivation to do your best in your presentation. And from the European project Human Ads, we used to have lunch provided for free. This year, as you've been around, lunch is provided by the conference. So we are scrambling together a dinner after the workshop, if you are not bored yet of each other and of us. I just made this morning a group on Whova channel, on the Whova app, called NLLP Dinner. If you are on Whova, just join there to keep updated, because I'm not sure where we're going or maybe exact time around 7:30. So we have some time to cool off after the workshop, and also have a number. If for some reason you're not on Huva, I'm talking about people in Suzhou, obviously, right? Just also approach me at some point and let me know, and we'll let you know. So thanks also to our sponsors for their kind contributions. This is the schedule, which is split in kind of 4 sessions. We also tried to keep the sessions as coherent as possible. Of course, take into account your preferences, but also time zones. As I said, we have people from Europe, India, and the US, and I'm not sure if I missed something else. But in principle, each session is broken into 2 sub-sessions, each featuring a series of papers in related topics, after which we take questions and move to the next sub-session. So the first one is going to be legal reasoning and arguments, a series of papers followed by questions, joined QA, and then we move to the emerging task, which is agents, trademarks, and negotiation, also by questions. We do have 2 coffee breaks and 1 lunch break. Lunch provided by the conference. You can also see the different themes here. I'm not going to go in detail over them. And before we start with the main program, I have some housekeeping rules which I made for myself, but also I share them with you here. So for all presenters, just check in with us at some break, preferably before your sessions. As I said, for the on-site presenters, you should be able to connect to the Zoom session that you should have received in the email we sent to the presenters. You mute your microphone, and you can share your screen present from your laptop, right? That's supposed to make things easy. It's what I'm doing right now. Mute and your mic and speaker, and you are heard through the internet, also in the Zoom and the YouTube channel as well. For online presenters, things are easier. You can just share your screen. There is a strict 5-minute limit for presentations. You'll get a warning or a signal at around 30 seconds before the end, and then I'll set a timer because I'm terrible at timekeeping, so there will be some noise. We take questions at the end of each theme to facilitate also questions, general questions, like some of the papers have joined themes, also to ask questions to each other. So for on-site attendees, maybe try to also remember the question you would like to ask, maybe take some note, the good old way. And for online attendees, use the Zoom chat as a placeholder, and we'll also try to take that question afterwards. We'll usually take photos of you presenting. We'll do that unless you tell us that, I don't want to take me photos. We just send them afterwards if you want to use them for any way. But again, if you have any problems, just let us know. We don't know the poster numbers yet. We'll know them at the lunch break. As you know, some of you opted to have some poster during the lunch break. So during the lunch break, we'll go for lunch and also enjoy some of the posters before we are back. Okay, I think that was it. So I think we are ready for the first, to move to the first presentation. Is the first presenter, which I need to procure now, in the room, or?
I am online. Hi.
Okay, great. Yeah. So you can share your screen and take it away.
Let me do that now.
You have 5 minutes, right?
Yes. Should I go now?
Yeah, whenever you're ready.
All right, nice to meet you all. I'm Joseph. I'm a researcher at Robin AI, which is a legal tech based in London and in the US, New York. And this paper is also in collaboration with AWS. So I'm going to present a method that is based actually on a product that we have at Robin, which is called Tables. So Tables is quite simple. We have a legal document, like an NDA or a vendor agreement or a side letter. And a client would set a list of questions based on that document and get an answer or a list of answers from the LLM. For instance, here, what is the governing law of the contract? And then it gets that it's the state of Florida and a citation along with it. Problem is that it's quite hard to actually evaluate this answer automatically without having a human review. It's also hard to get a useful evaluation, not just a score. It's hard to also evaluate it without a ground truth. And also it's hard to flag which answer should be reviewed as opposed to answers that you can trust. For instance, you probably all heard of DeepEval, which is an automatic framework, but which, as I'm going to show in a moment, doesn't work really out of the box for this task. So in this example, for instance, we have this employee NDA, we have the governing law question, and the answer is that the governing law is state of Florida, but for some reason the LLM says that the jurisdiction is in the USA. But that's not relevant to the answer. So DeepEval typically in that instance would say that this is the correct answer, but a lawyer would say it's only 50% correct because we don't really care about jurisdiction here, we care about the governing law. And so our solution was to build this LeMAJ, which is a legal LLM-as-a-Judge method, which is based first on how a lawyer would review an answer, and also based on some summarization evaluations that have been recently published, one paper actually last year at NLLP. And so how does it work is that first we consider this answer, the answer of an LLM, kind of as a summarization, in the sense that we can also break it into a legal data point, which is a piece of information that has some definition that we give to an LLM. So the LLM would break down the answer into these different legal data points, here 2, for instance. And then we ask the LLM to evaluate each of these legal data points. And for that, we actually classify the legal data point into 4 categories, which is correct, irrelevant, incorrect, and missing. So correct, the legal data point was correct. Irrelevant, it's something that is correct but should not be part of the answer. Incorrect is a hallucination, a clearly wrong statement. And also missing, which is not in the answer, but something that should have been added based on the legal documents. So that's the main method. From that, we can then compute a list of metrics, which is correctness, precision, recall, and F1. So correctness is based on the number of incorrect legal data points. Precision measures how many irrelevant legal data points there are. Recall is the number of missing one. And F1 is a combination of the precision and recall. So we have actually 2 main metrics, correctness, which is how much hallucination happened in a table, and F1, which is how relevant the answer are compared to the questions. Our experiments were based on 2 data sets. First, a proprietary data set that we have based on 45 contracts, and an open source data set called LegalBench. We also use 2 metrics. Actually, the main one is the Precedent correlation. So we just compare how correlated are our score against a human evaluation, which is quite natural. We also considered another metrics, which is bucketed accuracy, which is the nearest score. Like we basically average the score, take the nearest score compared to like a 0, 0.25, 0.5, 0.75, and 1, which is how a human evaluated the scores. And we compute directly the accuracy against this score. And we also compute our method against some baseline, which is Blur rule, so classical NLP metrics, and also BERT score, BART score, and also some LLM-based DeepEval metrics. And here are our main results. So here, let's focus more on the Pearson correlation, where we can see that actually most of these methods, actually the ones that are on top use a ground truth. That's something that I haven't specified, that here we have the ground truth available for each of these methods. And the lower ones, the DeepEval one and our method doesn't use any ground truth. So we can see that actually most of these methods have a very low Pearson correlation compared to our method, which is without ground truth. So it's not like a huge correlation, but it's still much, much higher than anything else. And so this was done, on relevancy, but we also done it on correctness, which is one of the metrics I've showed you earlier, and we can see a similar trend. We also compared interlocutor agreements because when we designed these experiments, we not only designed this LeMAJ score, but we also designed a user interface, which follows the same principle, where an LLM split an answer into legal data points, which are then reviewed by a human into incorrect, correct, irrelevant, and missing legal data points. And we show that using this user interface, users is using this way of evaluating answers, we showed that we increased internal total agreement for correctness from 0.77 to 0.88. But for relevancy, it didn't really change. It stayed around 54, which is a lower agreement since relevancy is a bit more subjective than correctness. Here I'm also sharing some production implementation because this was actually implemented in our product. We fine-tuned the Haiku model on Bedrock. This is where we got the help from AWS. We also did a bit of experimentation by doing some hyperparameter tuning, prompt engineering, chunking, data augmentation, and we also tried out an LLM jury by having several models working together, which we actually didn't implement in the end due to cost issues. And finally, the answers were flagged into different ones. So we would flag some answers which we think should be reviewed. The one where we think the correctness, like some of the answers is incorrect, like part of the answer is incorrect, and also some where the relevancy is below a threshold of 80%, and also the relevancy recall is below another threshold of 80%. This way, basically, we made sure that we had a high recall method where answers which were flagged, where answers which were not flagged were most likely correct, and only the answers which were flagged were potentially incorrect or irrelevant and had to be checked. So a high recall method here. And that's it for me. Thank you very much. I don't know if this is 5 minutes already.
Thanks. And we'll move on right to the second presentation.
Thank you. I'll stop sharing.
And I think all the next presenters are on site, so.
Hello, I'm Yehun Jang, a PhD student at Bugyeong National University. Today, I'd like to introduce our work, Pilot Bench. So far, there has been no benchmark that jointly covers both legal and patent domain. Existing patent datasets include only technical information and cannot evaluate legal reasoning. Meanwhile, legal datasets mainly focus on case law and therefore lack technical context. Also, previous studies on PTAB decisions have not evaluated the reasoning ability of LLMs, so we thought it was necessary to build a benchmark that evaluates LLMs' legal reasoning ability within the patent domain. We combined PTAB decision data, metadata, and USPTO patent records. Then we refine them through a pre-processing pipeline so that LLMs can perform the legal reasoning process step by step. As a result, Pilot Bench consists of about 18,000 appeal cases. We also designed 3 classification tasks aligned with the IRA's framework to structurally evaluate the reasoning process of LLMs using Pilot Bench. First, the issue type task, classifying the type of legal issue. Second, the board authority tasks, classifying the legal grounds cited by the PTAB. And finally, the subdecision task, classifying each detailed ruling. Since the application step, which applies legal rules to facts, is the most complex reasoning stage, so we did not include it as a classification task. We also split PTAP decision into 4 parts to ensure fair evaluation and preventing reasoning leakage from the PTAP's opinion. The 4 parts are appellant's arguments, examiner findings, PTAP's opinion, and facts. Among them, we gave the appellant's and examiner's arguments as input to the LLM and used information from PTAP metadata as labels. We evaluated 8 models in total, both closed source and open source ones. As a result, closed source models showed consistently better and more stable performance across all tasks. The performance gap was especially large in the board authority and subdivision tasks. We also analyzed performance differences depending on input design. We compared 3 settings. First, split base, where the appellant and examiner's arguments are separated. And second, merge, where the 2 arguments are combined into one text. And third, split plus claim, where patent claims are added on top of the split input. As a result, split and merge showed similar and higher performance, while adding claims actually decreased performance. This drop was especially large in the board authority tasks, suggesting that the added claim text introduced noise rather than helpful reasoning signals. To summarize, the contributions of pilot benches are threefold. First, the construction of a new benchmark dataset for legal reasoning in the patent domain. Second, the design of IR-ACID-based evaluation tasks. And finally, experiments and analysis across various LLMs and input settings. Through this work, Pilot Bench becomes the first integrated benchmark that connects patents data, legal reasoning, and LLM evaluation. Thank you for listening. Our dataset and code are available on GitHub via the QR code below.
I'm sure please control him. Okay.
Hi, and thanks for having me. I'm Lena, and I'm presenting the work that I did in collaboration with Ivan Habana from the Ruhr University of Bochum in Germany, and also from the Technical University of Germany, of Darmstadt in Germany. So our work focuses on how we can extract formal legal arguments using large language models. It's not working. It's not moving.
Yes, I'm not sure if it works, but
oh, thanks.
Yeah.
Okay. Sorry about that. So the idea is that argumentation mining was usually done with traditional models, so we can also use generative models for that. And Cavarada et al. 2024 have shown that we can even use something like a T5 model to incorporate basically the annotation into the output. So instead of extracting something or marking something, we would have an in-text annotation that is generated from the input text. And with this, we can use, in theory, any generative model, which gives us the advantage that we can also leverage much larger context, which can be beneficial in the legal domain as well. So, but the legal domain is a bit more complex, as we all know. So we chose a legal data set to test if it actually also is searchable for legal arguments. We chose a data set that is based on ECHR judgment documents and has 17 different, very fine-grained argument types, a few of them listed here, such as, for example, systematic interpretation, margin of appreciation, which are not only specific to the legal domain, but also very specific to the ECHR. It was expert annotated, so it is of high quality. And the data set contains multiple paragraphs, so each paragraph can theoretically be used in a generative fashion to include the annotations in the output. And first, we had to reformat the data set because it was actually in the traditional BIO tagging format. And so this is an example of what one data point can look like. So you have a begin of annotation tag, you have an end of annotation tag, and then you simply append the label and put end of label to indicate that the annotation is over. And so for that, we used the original Roberta baseline, which came with the data set basically as a baseline. And we also used the T5 model because it was so successful in Caravada et al. 2024. And on top of that, we tried it with decoder-only models to see if that also works with the Llama family in 2 different sizes. And we tried in-context tuning, learning versus fine-tuning to see if we actually need fine-tuning for this or if in-context learning is enough. And we also wanted to leverage the actual larger context of the model. So we added not just the target paragraph, but also the previous N paragraphs to the input. And to give the full context, we also included the entirety of the document, which in the ECHR judgment documents can actually be quite long, to see if that also works. And on top of that, because the argument labels are very specific and not very commonly known, we also added annotation guidelines to give a better idea of what the argument label actually means. And so for evaluation, we focused on how well we can identify the argument component in each paragraph, if there is one, and also how well it is classified. And because we're using generative models, we also need to take care of that the output is actually in the correct format so that there is a begin tag, end tag, and so on. So we measured these things, and these are some of our results. I'm not going to go into full detail for the sake of time here, but the main takeaway is that the legal Roberta model, which came with the original data set, was not beaten by any of these models, despite fine-tuning, despite in-context learning. But we can see that the fine-tuned models, which are, for example, the Llama models with the different context sizes, they stick to the component identification quite well and also to the output format validity. On the other hand, we can see that in-context learning was most of the time not enough to get the correct output format. And using the full document, even with fine-tuning and annotation guidelines, also tended to cause more confusion than actual benefits in this case. And another thing we can also see is that although we used different model sizes, the difference is not that big as we would have expected. But we can see a slight trend that context does help a little bit, but not to the magnitude that we expected it to have. So we can also see this when we look at the concrete argument types. So these are sorted by prevalence in the data set. So there is, for example, the application to the concrete case with the most prevalent label, which is way better a little better in the Llama model, but at the cost of losing the performance in the lower represented labels. So the basic takeaway from that is the training with these underrepresented labels is actually pretty complex and is even more difficult in generative models than it is in encoder models, for example. So encoder models have a slight advantage here. And the format is actually easily learned through fine-tuning. So that's a good thing. We can theoretically take this method for generative models as well. However, the annotation guidelines in our case did cause more confusion than benefits. And also the direct context was not as beneficial as we had hoped. So maybe there are different methods we could use to incorporate the context better into the classification. So thanks a lot, and be happy to chat if you want to have during the break.
Okay, hello everyone. I'm Davide from Thomson Reuters, and today I'm going to show some of our latest work in test time scaling for legal reasoning. So test time scaling is a very simple idea. Like, we just want to use more compute at inference time to get a better performance. And there are many methods, but we wanted to focus on these parallel methods where basically you generate multiple candidate answers from your models, and then you kind of select, like you score and select the best out of all of them. And to select it, actually, you use some of these reward models, or also called verifiers, and they're actually very important in the performance of these methods. And in math and coding, actually, they were proven to work pretty well, these methods overall. But in law, actually, no one tested till this point. So what we wanted to explore was actually, if, first of all, these methods are worth to use compared to simply using majority vote, or we wanted to explore if which aspects of the verifier are actually more important, and if some legal training is actually useful in this case. Then finally, we wanted to explore also the architecture of these reward models, if some process reward models available now are actually better than some outcome reward models now. And so this is kind of our experimental setup. We took llama models from very small ones, like 3 billion, till also 70 billion ones. We took some reward models. We have actually quite a lot. Some are proprietary from Thomson Reuters, where we also train on legal data, but also some that are more general reward models. And I also want to mention this latest work, Versa PRM, which is a PRM trained on multiple domains, including law. And we wanted to test these three different methods, basically majority vote as kind of a baseline, then best of n, and this DVTS algorithm, which is a tree search algorithm. And we tested on multiple choice legal reasoning benchmarks, which are of different kind of complexity, from binary to 32 options per question. So I'll just go straight actually to the takeaways. Sorry, here there's just a typo. Here we used Skywork reward model 27 billion in this case. And what, first of all, we saw is that actually with big models, with big generative models, if you can afford to use it, actually you might not need to do any verification. You can just do majority vote. But with some smaller models, we got some improvement with general reward models available. But just another important aspect is to look at the individual benchmarks. And what we found out is that if we have the possibility to use also bigger reward models with complex tasks like this one, like a LexAM 32, which again, imagine has for each question 32 options, which is quite complicated. In this case, then majority vote fails alone, and using verification with some good reward models actually gave us very big improvements. In this case, relative gain is compared to majority vote at the same budget. Then another part that we wanted to explore is if actually training a reward model on some legal data was useful. And in our case, seemed yes. But actually, there is a caveat. We noticed more improvement when also we scaled the reward model parameters. And so it seems like it's a good investment to invest in these 2 points. Then regarding the structure, actually, the architecture, we noticed that PRMs, at least the ones that we tried here, again, it's a limited setup, but this Versa PRM actually beat our reward model that was trained on legal domain. But still, of course, it doesn't beat the 70 billion one. So these are just the main takeaways again, as a recap. So we noticed that there's these diminishing kind of returns from using these methods when you use bigger generative models. But the task complexity seems an important differentiator in the actually, let's say, improvement we get from these methods. And finally, yeah, we noticed scale and specialization are useful to invest on for these reward models. And also we noticed these process reward models seems to generalize better, at least in our setup. So these are just 3 points we are going to work on next. And there's the paper, and we are also hiring for research roles if you are interested. Thank you.
Hello, everyone. I'm Odysseas. I'm going to present you today GreekBarBench, a challenging benchmark for free text legal reasoning and citations. Legal benchmarks in legal benchmarks, it's very important to have long-form reasoning. Even the best benchmarks, such as LexAM, often omit legislation text from the context. This tests memorization, not reasoning. Here we present GreekBarBench, which is based on the Greek bar exams. We test 5 key legal areas and 310 questions with long-form answers. We have 16,000 relevant Greek legislation articles that you can cite from. Let's see an example. We present to the LLM the facts of the question. The question itself, for example, here, which individuals are liable for the injury. We present the relevant legal context, which is the legislation in Greece. And we also have the ground truth answer to compare to the LLM's answer. But how do we evaluate legal reasoning in practice? We ask the LLMs to provide citations to the facts in the articles that they used. We also have 3-dimensional scoring to be able to distinguish which parts were hallucinated or there are mistakes and which parts of the answer are correct. We have the dimensions are facts, articles, and analysis, as you can see in the example. The final score is just the mean of the 3 dimensions. This is a unique benchmark in legal NLP because we actually use LLM-as-a-Judge, but we also evaluate LLM-as-a-Judge separately. To do this, we have a benchmark with evaluations from the experts, and we compare the judge's evaluation with these. We actually see that GPT 4.1 Mini is the best judge, and it has very good agreement with the experts. Let's get right into the results. Most LLMs pass the exams easily. The passing score is just 6 out of 10. Still, they are far behind the top legal experts, which can even get to 9 out of 10. Gemini 2.5 Plus and GPT 4.1 are very impressive, and they are the best LLMs at this task. We also can see that we have the 5 legal areas, and we can see the different performance of LLMs in these areas. Some LLMs are better than others in other areas. It's very interesting that we also can see the distinction of the correct legal articles is more important than just memorizing the law in your internal memory. For example, we did an experiment without giving any context of the legislation to the LLMs, and we see that GPT 4.1 is very weak at this task because it doesn't know the legislation. It hasn't memorized it. But when given the legislation in its context, using essentially something similar to RAG, it gets much better. And if we give the perfect Oracle context, it gets almost perfect scores. We also analyzed the 50 worst LLM responses and found key errors in the different dimensions that we studied. As a conclusion, the Greek legal NLP landscape is steadily developing, and we are aiming to build a strong foundation for the future. Thank you.
Based on the program, the next one is not coming because of findings paper. So we'll move to the last of the first session, who is Argia.
Hello.
Ah,
Orgo
you're online.
has a family emergency. I'm filling in for Orgo.
Okay.
Okay.
You can share your slides and
Yeah,
take it away.
sure. Is my screen visible?
Yes.
Yes.
Yeah, thank you. Myself, Kush. I'll be presenting the paper, Are LLMs Quote Ready, on behalf of our team at Adalat AI. To give a bit of motivation for this study, the law is jurisdiction specific. So the existing benchmarks that we have, which are ILTR, LexClue, LegalBench, or the Lee exam presented earlier, all these exams, first of all, are not jurisdiction specific. Since at Adalat AI we build for courts, it's important that our court partners and our stakeholders recognize the solutions we build for them. And hence, we test the frontier legal models on, on, on the exams and the barriers that gatekeep human entry into the Indian legal ecosystem. Such papers are the undergrad examinations of CLAT or judiciary examinations for Delhi, or even the Supreme Court examinations called the Advocate on Record. Next, I'd like to give a breakdown of the dataset we have created. It has about 6,000 MCQs spanning 4 exams: CLAT undergrad, CLAT postgrad, Delhi Judiciary, and Delhi Higher Judiciary. All these exams cover a lot of Indian jurisdiction-specific law questions, whether it is the Indian Penal Code or the Indian Constitution or Indian tax law or Indian customs law and everything. Advocate on Record examination has 4 sections: practice and procedure, advocacy and ethics, drafting, and leading cases. We exclude drafting from our evaluations because LLMs don't know how to draft. Without given the proper format and exact, very pinpointed instructions on how to draft, they have not yet memorized how a Supreme Court or how a High Court petitions or pleadings can be filed. One of our evaluators deemed the petitions drafted by LLMs non-evaluatable. Moving on. Our Advocate on Record exams, the one conducted by Supreme Court India, is pair blinded by 5 different Advocate on Record graders. The graders are Advocate on Record themselves. As I said, we have excluded drafting from our evaluations. How do we evaluate these models? Our prompts are very specific to the exact exam instructions given in the paper. We run them at 0 temperature so that they can be reproduced. We do not account for runtime to runtime variance. We snapshot the models at runtime. We also enforce a strict JSON output schema so that the models adhere to some sort of structure while giving out the answers. Now, for a subjective exam like Supreme Court's Advocate on Record exam, there are certain rules on how the paper should be evaluated. There is citation discipline, there is forum structure, there is depth, there is language. All of these rubrics are kept in mind by our evaluators while scoring the models. On the various objective exams, that is CLAT PG, DG, and judiciary exams, frontier language models beat human topper averages every year by huge margins of even 20 points. The topper numbers that we have are released by the exam conducting bodies themselves. Hence, the average of over all the years is very stable, and frontier models beat these benchmarks regularly. But when we come to subjective exams like Advocate on Record, which actually test what it means to practice as a lawyer in the Supreme Court of India. LLMs fall way bar behind. If you see in practice and procedure and leading cases, they are almost 10-20 points behind, with parity in the advocacy and ethics section. Now, it may seem 10 or 20 points, but for the Advocate on Record exam, it's actually a very huge ground to cover, and LLMs are nowhere in the race. So where would I today use LLMs? I would use them for precedent lookups, consistency passes, and checks on my work, but I would not use them for drafting filings, remedies, or, drafting my arguments, or, or even auto citations. I would not use them today, as I would only use it as my assistant or companion, but not as the first pass. So what can we do further is that we can still put guardrails on our LLM systems, that our drafting can be template bounded. Our verification can have a very strict knowledge base. We can also, since these exams are conducted yearly to gatekeep human entry, we can keep re-evaluating the LLMs to see where they are at and see their progress. But right now, as I said, they are great at short context, recall oriented tasks, but not at long form reasoning, which is tested by the Advocate on Record examination. Happy to discuss more details like reproducibility, guardrails, limitations of our paper during the QA session. Thank you.
Thank you. So it's time for questions for all presenters. I'm not sure if that mic works. Does that mic work? Meanwhile, I think there's a question for Lina. I will read it from the chat from Leslie. Can you say a bit more why you think Roberta beat newer, larger models? Also, have you considered extracting an argument graph as this structure have interrelationships? Yeah, I would say maybe come because we don't have any other microphone, so otherwise the people on Zoom won't be able to hear you.
Yeah, thank you. That's an excellent question. So about the Roberta models being better than the larger models, I think that is also a great cause is the structure of the texts. So a lot of these arguments are very rigid, and the forms that were used to create them are also rigid. So it might be easier for an encoder model to actually understand how the sentence is formed, or if there are certain key phrases or key indicators that make it easier for an encoder model instead of a large language model or a decoder-only model. But I think that's also the downside of it, because that means that the encoder model wouldn't really understand what the argument is. It just notices the form of the argument and not actually content of that. And regarding graphs, the data set did not have any graph structure or relationships. So we did not include that here, but that would be interesting because you could actually also do that with this in-context format. And this is what the previous work in the general domain also did, including relationships on top of just the argument types. Well, thank you for the question.
Thank you.
Any more questions for any of the presenters or presenter-to-presenter interaction? Yeah. But I think you need to come here, otherwise the people on Zoom cannot listen to you. So we really need that microphone fixed.
Yes, a quick question for David. Actually, did you try any larger models like frontier LLMs, or you cannot use it because of like proprietary data? Can you hear me? or actually larger reasoning models, for example.
So you mean like if we can, sorry, I didn't maybe get the question exactly.
Yes, the question is like if you tried any larger reasoning models apart from Llama. I don't remember exactly what else you had. Yeah. And also if you tried any like frontier closed weight models.
Yeah. Unfortunately, no. We didn't try like other models, though I think it would be interesting. But I just would say like, for example, reasoning models that are trained to generate much longer reasoning chains. I think, yeah, it's like maybe unfair to compare it like to, let's say, normal or regular language models. Because again, we are like, I don't know, generating 16 answers from Llama models, which are quite short. If I generate 16 answers from a DeepSeek model, it's gonna be much more expensive. But yeah, we are also gonna plan to like include more models on that. So I can also send you some results. Yeah, thank you.
Yeah, you have to come here, because otherwise people online cannot hear you. Who is the question for?
I got a question for the author of the Greek NLP benchmark. Yes, by the way, thanks for the sharing of the Greek work. But the specific question is, can you tell me a bit more about how the rationale, how you choose the evaluating the legal reasoning part, and how is the score for the hallucination like exactly works? Yeah, thank you.
So we have tried to, thank you for the question. We have tried two methods. We have tried to give the LLM, the simple method is to give the LLM as a judge the ground truth answer from the human judge that created the question. And in the answer, you can find the correct legislation citations. So you know exactly which legal articles are the correct ones that you must use. This is the hardest part of the task, and it's the second dimension. So you assign a score from 0 to 10 in this dimension. You also have to mention which facts were used in your legal reasoning to answer. And this is the fact dimension. And the analysis dimension is the last part. This is the score that you assign to the legal reasoning and how well you answered the original question of the task. So maybe you understand the question, you understand the correct facts, and you understand the correct legislation, but still sometimes LLMs make mistakes and they don't answer the question correctly because they don't know exactly what should happen. So that's the evaluation. And then we tried something even more complex where we give the LLM some human created from lawyers, some instructions on what parts of the answer are the most important. So we highlight the important keywords from the correct answer. And this helps to evaluate even better, with better agreement with humans. Thank you.
We still have time for questions, so, and the microphone works, so you don't have to come to the mic. Any more questions for any of the authors of the first batch? I think, let me compare because I had one question for Joseph. Joseph, are you still online?
I am, yes.
Cool, yeah. I had a question for you, but let me also find my notes because I was multitasking. Can you say something a bit more about the metrics you had? Because you had a bit of the correctness, the F1, right? The relevance, and also the
Yeah.
alignment metrics? How do they? I mean, I was trying to think if they are kind of complementary, or so. I was trying to think if, yeah, they bring something new in terms of, let's say, reliability, or how can we trust the LLM output? And can you compare a bit which one you
Yeah.
focus more, or yeah?
So there are kind of two dimensions in the sense that one is more on correctness, so like hallucinations, factual errors. The other one is more on relevancy. So how relevant is the answer based on the question? So an irrelevant answer would still be correct technically, but would not actually be answering the question. So that's kind of the two dimensions we're looking for, because this is, from what I understand, talking with lawyers, is where like the two potential issues are coming from when we do like question answering on legal documents. So this is a tool we're like really looking for. When we do like implementation in practice, we would flag any incorrect answer. So even if part of the answer is factually incorrect, we would flag it no matter what. So it's kind of like a first check, and then relevancy would be based on a more softer threshold because it's a bit more subjective. But if CLM puts like a score based on our method a bit too low, which is under 80%, then we would flag it for lawyers to review. Does that make sense?
Yeah. Very clear. Yeah. Thank you.
Thank you.
Question? Yeah. You can try the microphone unless you want to come here for the.
For the Indian branch.
Yeah, they are online, or they should be online. Yes.
Yes.
Yes. I want to ask. Can you hear me?
Yeah.
I want to ask if you what you think needs to be done to evaluate the legal drafting, and what are your thoughts on future work on that?
Sure. If I would like to quote one of our evaluators, they would say that the legal drafting done by LLMs right now wouldn't even pass the registry stage in Supreme Court. That is a check before the petition actually reaches the judge for his or her perusal. So the fact is that LLMs cannot follow any kind of drafting instructions. All drafting questions had 5 to 6 instructions on how to actually draft it as well. So to do that, we need some sort of structure. Like if you look at editor templates, you can actually have canvas-based writing. Maybe we can train the models or use existing solutions so that LLMs follow a template in writing. And we also need to supply LLMs with format on actually how these petitions are filed, because without those, the LLMs are just going everywhere. So maybe we can do an evaluation with these constraints defined to them, with the template and with the formatting supplied to them. However, this study was limited to the actual exam conditions as to how a candidate would actually sit and give the exams. Hence, these constraints were not given to the LLMs, but we can still do that and evaluate again as to if these constraints are applied, can LLMs do better? I hope that answers your question.
Yes, thank you.
Any more questions? We still have 2 minutes to be right back on track. If not, maybe I have one question for the pilot bench. That's you, right? Yeah, no, don't worry, it's easy. So you had this opinion split method, and I was wondering how, I mean, how essential it is, right? So do you have any idea why it's helpful? I mean, does it help the reasoning, or does it help the context, or any thoughts on that also? Because this IRAC method has been, let's say, a bit criticized. So any thoughts?
I think the splitted context is helpful for reasoning of PTAB when they read the opposite side the opinion. So it helpful for the LLMs reasoning that. So I do yes.
Okay.
Yeah.
Yeah, thanks. Okay, cool. So somehow we are back on track, and then we have 3 more papers before the first coffee break, which are under the what we call emerging tasks. So they are a bit on agents and negotiations and trademarks. They are all virtual. So is the presenter of the next paper in the Zoom? The automated by risky game modeling agent to negotiations and transactions in consumer markets. I'll take this long pause as not being there. In that case, I propose we move to the next one, the LegalSim, multi-agent simulation of legal system for discovering procedural exploits. Single author paper, and I think I saw Sanket online.
Hey, just give me.
Great. So you can share your screen and start.
Yeah. Can you guys see my screen?
It's about to show up, but yes, it's showing. There might be some lag, but yeah, you can start. 5 minutes, right?
Okay. Give me a second. It's lagging on my end. Just give me a second. Just sorry.
Well, the Zoom here shows that you have some connection issues, but now you're not sharing.
I tried to share, but then it just froze on my side. Yeah. Are you able to see now?
Yeah.
Yeah. So hello everyone. My name is Sanket. Sorry for the connection issue. So today I'm presenting the our work LegalSim. So this is like a new multi-agent simulation framework. So we have built this particular framework to answer a simple question: what happens when an adversarial AI agent just stop just stop their reading the law and start playing with it? So right now, most of the legal AI work that is being done is more focused on the passive. So it summarizes like the different contracts, it retrieves the relevant cases, it helpful, but it's not actively being used as a tool. But we are more moving towards like a world where agents will be directly interact with the legal procedure. And history has given us a lesson that whenever we are giving like optimizing agent like a complex rule, it just not follow those rules, but it will also find some loopholes and it will try to crack those rules. So our hypothesis in this work was simple. In a simulated legal environment, can agent be lawful but also awful. That means they are trying to find the exploits that are technically legal but are socially harmful. So we built a legal system as like a multi-agent reinforcement learning environment, and it has different legal procedure. So it has mainly 4 core parts. So first, as rule as a code engine. So in this particular part, we load different legal regimes such as like a bankruptcy or tax related laws as a JSON files. The second is basically structured action space. So where we have 13 different actions such as automatic stays, etc., procedural grades, and that can be take a decision on a particular case. Third is basically a state representation, so agent can see budgets, accumulate a burden, and the full case history until that to informally make the decision at that particular point. And finally, we have like a stochastic judge. So instead of like being a one particular judge, we tune this particular judge to be a strict or permissive, and letting us test if the exploit work universally or only against a specific judicial personalities. So we basically model a litigation as a multi-agent adversarial game, and which are basically governed by the different JSON procedure that JSON-based rules that we have. We have 2 agents, one is plaintiff and one is defendant. They in this particular structured environment, which is mediated by the judge that we have. And the objective is to allow learning agents to discover strategies from this particular environment dynamics that we have. So we tested 4 different agent architecture to see how to approach this particular problem. First, we use a PPO. So this is like a standard reinforcement learning approach. So this particular method is great at like finding the direct path and to maximize the reward function that we have set up, and the select action from the environment based on the rewards that it's getting. The second is like a hybrid contextual bandit. In this particular method, it's a combination of LLM and one particular tactics that can be like delay the trail. And then we use this LLM to translate that tactic into a specific valid legal action. The third is direct LLM. So we use GPT-4 reasoning model with zero shot to give entire history of the case and the existing state, and propose the next move based on that. And finally, we have some hand-coded heuristic, and that serves as our baseline model. But in the real world scenario, winning is not everything, right? So the goal is here is also pressure. So we have created like a composite exploit score. So this score is a formula of like inflating opponent cost, dragging out of like calendars, forcing settlements. So on all of that, we have given a different score to determine which is better. So we have done a variety of different experiments. So these are some of the evaluation results. The first is like a cross-play heat map. This particular shows us how each policy performs against each other. So we have like 4 different methods, and we ran each methods against each other to see who is winning. Overall, we have found that in this particular method, the contextual bandit was like most consistent, though LLM has higher winning rate against some policies. But if we look at the contextual bandit, its win rate was above 56% in most opponent type. On the right-hand side, we have in the table, we have like overall effectiveness rate. So it is the average win rate across all the games, roles, and judges that we have. So in this one, we have found the PPO achieved the highest raw win rate, which is around 74%. But again, the contextual bandit was very close. So I will say the overall contextual bandit gave us the best performance. The third and the fourth column is our overall exploitness score. So it's basically suggests how much each particular agent is trying to exploit, but exploitness just don't give you winning. That's why for some of the heuristic use, we can say that they just spam one particular pressuring tactics bluntly all over the place, and that is not just optimized. So yeah, so the winning agent is with the overall is like PPO, but contextual bandit is for all the different metrics, it was more consistent. So what was the conclusion? So we have kind of created a legal simulation, and here we are trying to do a rate teaming of the law itself, so we can go beyond testing model accuracy and evaluation to the robustness of the different codified law systems that we have against adversarial AI. And by identifying different exploit chains in simulation, we can anticipate and mitigate risks before they can be manifest in the real world. So yeah, so in this framework, we are in the future might want to create more guardrails. So yeah, thank you so much.
Thanks. We take questions also after the next presentation, so stay with us. And I think I saw already the next presenter in the room. Great, she's here. So you can share your screen and start whenever you are ready.
So, can you see my screen right now?
We can see your presentation. It's not full screen, but we can see it. We can see your screen. Yeah, cool.
Can you see my screen? Okay. Hello, everyone. Today I'm going to introduce our work, which is modeling the distinctiveness labels into a continuous trademark scale via synthetic anchors. So why distinctiveness it matters in this case? So in the U.S. law, the U.S. law grants the trademark protection based on the distinctiveness of a trademark, basically how strongly a mark can identify the source of the services and products. Distinctiveness determines the eligibility of the trademark protection and the strength of the trademark's owner's rights. So in the US law, the Abercrombie spectrum is established 5 legal categories, based on the different strengths from generic, descriptive, suggestive, arbitrary, and fanciful. So in the generic trademark is basically employ the common name like aspirin, and this is the lowest protection strength for trademark, and then the highest protection strength is arbitrary and fanciful, which is like Apple for computers and Starbucks for coffee, because there's a strong connection. If you are saying Apple for computer, this is a computer. So this is a different strength of a trademark. And so the problem is the court always use the humans to determine the distinctiveness of a trademark, but the human judgment is always subjective and inconsistent across different contexts. So the boundaries are inherently conceptually fuzzy and context dependent. So our goal is to trying to build a label-free continuous scale that can quantify how distinctive a mark would be, rather than assign hard legal categories for each trademark. So the goal is to build a continuous trademark distinctiveness scale without manual labels. So this is the pipeline. First, we use the LLM to generate synthetic anchors. So basically generate a mark and context-dependent description pairs for each Abercrombie level, from generic to fanciful. And this is an example of for assault. This is the mark, and the salt for table salt is generic trademark, and salt for skincare is more fanciful or arbitrary. That's a strong connection to another kind of a context. And then we use LLM to compare different as a judge to compare which mark is more distinctive based on the context. Then we next feed a brand Terry model. This is a probability model. We wanted to estimate the latent distinctiveness scores for each anchors. So for synthetic anchorage construction, we use GPT-4o to generate 5 synthetic variants where we keep the mark constant. We only vary the goods and services context. And then we use both GPT-4o and GPT-5 to do the pairwise comparison. There are 2 types of comparisons. There's one within group comparison and the intergroup comparison. Within group, we basically compare the anchors of the same mark. And the intergroup, we wanted to bridge across different marks to unify the synthetic scale. So there's 2 bridge strategies for intergroup. There's random and a chain link. The random is just a randomly pick 2 marks from the synthetic the anchors, and chain link, we wanted to connect all the marks into a loop. And then we use the Euler comparison from the LLM to feed a Brad-Terry model to infer the latent distinctiveness scores for synthetic anchor. After getting the anchor scores, we wanted to map the real trademark projection on the learned BT ruler. So it's basically, we wanted to compare against its 5. So the real trademarks of 5 anchors, and the score, the real trademark score is interpolated by the on the learned scale using the synthetic data. So this is the results we got from the fitted scale using the synthetic score. So we see, both GPT-5 and GPT-4o can yield very identical trends across different strategies. We see the generic trademarks has lowest score, and the fanciful arbitrary scores tend to be higher. And then the next, we map the real trademarks on the learned synthetic ruler. So in order to validate the alignment between the trademark, the real trademarks BT score with the expert labels, we use the 3 different metrics to evaluate the correlation. So we see the both GPT-5 and GPT-4o has the high and reasonable correlation, especially the GPT-5 with the chain link strategy. We see the Pearson has 0.724 correlation score. This is a box plot. Now also see the generic suggestive those lower strength trademarks has a lower score, and then arbitrary and fanciful those the higher strength has a higher scores on both GPT-4o and GPT-5. So what we learned from the project: first, we learned the BT scores can expose the gray areas between the categories labels, the hard labels, the Abercrombie label, Abercrombie spectrum, and the continuous values can quantify the uncertainties of the distinctiveness scores of the trademarks on different contexts. And also we see the GPT-5 yields for the better results than the GPT-4o. For limitations of our future work, we first. So our current work is evaluated on a small set of data. So we wanted to scale up to the more data to see if there's better results or insights from more data. And also we wanted to explore the human AI collaborations. Right now we only use GPT-5, use large language models on the judgment without human involvement. So we wanted to further explore the human AI collaborations on the legal decision support. So thank you so much. And there's a QR code, you can scan it and see the demo online.
Thank you. Before we take questions, is there by any chance the author of the paper we had to skip in the room, or it's a no-show? Last call. Okay, otherwise, I think I take questions for these 2 papers, which are also a bit new tasks. So are there any questions for either of the paper, the LegalSim or the trademark scale? If you are online, you can post it on the chat. In the room, we have the microphone working, so you can go there. Yeah, this says go. Yeah.
Hi, I have a question for LegalSim. Thank you for the excellent work. Sorry, but I didn't hear, maybe you said it already in the presentation. What country is the legislation from that your system is based? My question is, how easy is it to adapt to other legal systems, to other countries, and what might be the challenges that you can think of?
Right. So that's a good question. So this entire work is we have created a simulation. So we take some of the examples. So this was totally example. It was not on any kind of real world data set or anything. We have take some penalty codes from tax laws, etc., and we just create a simulation out of it. So it was not a country specific, and it was based on the some part of the some penalties are not on entire law. I hope that answered your question. So this was entirely in simulation.
You want to follow up? Yeah.
Oh, no, okay. And how could it be more realistic? What do you think?
Yeah, that's a good question. I think there are some examples similar to this in some other use cases, right? So uh, if you can represent our entire law system as in a kind of rules, and how each of those are connected to each other, and how can we decide in each of cases who is particularly is gonna be has like how much score that they can get, so that basically we for each of those moving systems, if we have the scores, then we can make decisions out of it. So more systematic way of the representation, like creating environment, is the biggest hurdle, I'll say, and the biggest contribution that can be done. So
Thank
that
you.
once the environment has been created, we can run this kind of multi-agent systems on that environment to see who is going to be the winner in each particular cases. So for games and etc., it's pretty easy because there are predefined rules. But for legal laws, it's more complicated than that.
Thank you very much.
Thanks. Any more questions? If not, then I have one question for the other paper. Hui, I'm not sure if I'm mispronouncing your name, but my question is about, first of all, it's a really cool task and different than the things we usually see. So I was at least quite happy to read it. But I'm thinking like, because you are generating these synthetic anchors, right? And I think if I got it correctly, you fix kind of the mark name. So, I mean, is that kind of maybe big limitation in the sense that how can we create maybe true, let's say, I don't know how to call them, fanciful marks? Or yeah, how do you think maybe affects the limitation of having this, I guess, reliable, also continuous distinctiveness scale?
Yeah, that's a very good question. So we see you mentioned the fanciful marks. So for fancy markers, it's a kind of a new kind of categories, different from other, spectrums, categories, because the fanciful should be a invented word instead of existing word. So that's a big limitation in this project. So for now, we because we want to do some anchors to just to get the score. So that's why we wanted to fix one thing in the experiments. So that's the mark we can easily fix. But for the context, we see there's different variations from the LLM. LLM is really good at it. To do the random generation. So that's the same. That's the one of the biggest limitation we see. But for future, I think we can I'm thinking we can prompt the LLM to do the fanciful trademark generation separately, like, give the separate commands, like generate new words instead of existing words. But also we also wanted to have some connection to the fixed trademark as well, but it's invented in some way. So I think that's something we think might be useful for generating fanciful trademarks. And also we wanted to involve legal experts on trademarks in IP law specifically, and see if they can bring some insights on this regard.
Cool, thanks. Any other question? Or I have a short maybe follow-up. It's like, because of course this is kind of a new domain. How do you think, I don't know if you have any ideas on how you can, are we far, or is it easy to practically deploy such a thing in a, I don't know, legal decision support tool, or any thoughts?
Yeah, that's a very good question. So I have created a demo. I don't know if I can show here. So this is there's a QR code. Let me see. So there's a demo. You can see that. So this is I guess the demo can give you some sense, how might work. Let me see. Where's the?
Yeah, you can share it, because in any case we're on YouTube, so people might see it later and check
Okay.
it. So yeah, but
Okay, got it. So this is, yeah. Let me share my screen right now. Can you see my screen now? So this is the little
Yeah.
demo I show here. So you see, this is the distinctiveness scalar for the anchors and the selected real marks. So for example, on the left hand, this is real mark salt. So and the original context is for packages of sodium chloride. That's just salt. So let's see this. The little cross here is this a real trademark. So you see it's on the way left of the scale. So we see, we get sense. Okay. So and the anchors are here. So this is from generic to fanciful. You see it's on the left side of the anchor. So we could see, okay, so this is the salt would be more generic than the fanciful or than the descriptive. And also there's another example I want to show you, maybe H2O. So this is real mark, H2O. The mark is for bottled water. It's also a generic. And also you see the after generating the score, you see also on the left. So this is more generic than the fanciful. Yeah, let me see another. Penguins. I guess this is arbitrary. So penguins for bus service. So this is arbitrary. So this is the gold label from expert. So you see the selected trademark is basically in the middle of the anchor. So arbitrary and the fanciful. You could say, okay, this is the fanciful. It's not a really fancy trademark because the word of penguin is existing in the world. So this is more like a arbitrary than the fanciful. So I guess this is a little demo just to show you how we could use as a tool, to inform people, how the trademark would be interpreted in numbers or in visually, instead of the context would be very fuzzy and different people have a different opinion, and the LLM can give us some sense, how we could interpret certain trademark.
Okay, thanks. Thanks so much for this. And with that, we are going to wrap up the first session. It's time for the first coffee break. We are a bit not fully aligned with the full coffee break because we're supposed to have it at 10:40, so we get a bit more time. So we're back at 11:10 sharp. Meanwhile, the presenters of the next session, if they are in the room, just check with me how you're going to present. And another housekeeping announcement is that I found some goodie workshop stickers in my bag. So if you want one sticker to be a groupie of the workshop, you can pick them up from here. Otherwise, we'll see you all back at 11:10, right? Thanks to all the presenters so far. Looking forward to the next sessions. Sure. Hi. Okay. Have you gotten the instructions of, let me mute this so that, yes. Okay. We are about to start the next session. I hope people online can hear me because you had some microphone mess up. Okay, I'm still chasing some people that they're spending more time in the coffee break than they should have. But meanwhile, I think we can get started. So the next two presentations are online before we move to on-site. As a reminder, you have 5 minutes, and we take questions at the end of its theme, joint QA. So I don't want to steal more time. So Mikhail is next. He's already there, already loaded. So take it away, the next 5 minutes.
Okay, thank you, Jerry. Okay, hello everyone. My name is Mikhail Demir. I'm a PhD student at University at Albany, SUNY. Today I'm presenting our paper, which focuses on evaluating how language models can help us automating validation of case law, which is a core part of legal research in practice. So I'm starting with what validation means in this context. So authority validation is the critical process of determining whether a previous judicial decision is still considered good law. So let's say a lawyer wants to use a case in a legal brief, and let's call this case seed case, which you can see in the diagram. So however, cases does not exist in a vacuum, right? They are under constant criticism, correction by other cases, and this is especially true in common law system. So over a certain time, new cases starts treating the seed case, and the seed case can get reversed, overruled, criticized by the subsequent cases citing the seed case. So long story short, you need to make sure that the case you want to use in your brief should still a good law, and this type of validation is a professional requirement for a lawyer. And the historical way practitioners have validated authority is by relying on commercial citator services like Shepard or Keysight, which provide signals to quickly tell a lawyer if a case's authority has been weakened. So this validation is provided as a service by these companies. However, this process is costly, prone to error, which revealed by many citator comparison studies, and this leads to our motivation in this study. So the main question is how accurately can modern language models perform this complex legal reasoning task accurately? And to do so, we need a set of cases, right? We need seed cases, we need cases that citing the seed case, and we need expert annotated answer to the citing relationship with them. And there were a couple of datasets publicly available for this effort, which we examined. One of them was casehold, which didn't work out for our purposes because we really want to put the LLMs legal reasoning capacity into test to see whether they can classify a citing relationship in detail. But existing datasets were classifying whether the seed case is overruled or not, type of binary classification. So since there were no available dataset, we reached a legal librarian in William and Mary Law School. His name is Paul Hellier, and in 2018, he compared and checked whether commercial citator tools are given accurate and consistent signals for citing relationships. He thankfully provided us a near to 400 citing relationships, which he annotated. And these commercial citator services provide a lot of detailed labels. As you can see on the right-hand side, there are 16 unique labels that Paul provided to us. But after some discussion, we decided to group some of those labels and create an additional high-level category of labels, which derived from the original fine-grained labels that Paul provided. And we tested models on these two different classification tasks. So you can find more detail on how did we create, retrieve the full case text and process them in the paper. I want to talk about our setup a bit here. As you can see on the right, we provided the LLM with the seed case it needed to find and the full text of the citing case to give us a single classification of which label is the most appropriate for this treatment in a JSON format. And we then benchmarked the models using zero-shot and few-shot prompting. Again, you can find the full prompt in the paper's appendix. So our first results show the standard accuracy, which we believe quite promising considering the level of detail for each of the classification schema. Gemini 2.5 Flash was the top performer on the practical high-level task, which has 5 class, and GPT-5 Mini performed best on the complex fine-grained task, which has 17 class. But standard accuracy doesn't tell us the whole story because all errors are not equal. Right? Confusing and, let's say, invalidated case with a neutral treatment is far severe than confusing it with criticized. That's why we put this severity scale from 1 to 5 to measure the magnitude of an error. So let's say if the model classifies a citing relationship as invalidated, but the true label was limited or distinguished, it gets 5 minus 3, 2 penalty points. And then we take average for each citing relationship to produce average severity error for each model. So a lower score is better here. Limitations, we have lots of limitations. We tested a limited set of models. Our data set is from a single jurisdiction, and we use simple prompting, which we want to iterate in the future by using retrieval techniques. So in conclusion, we operationalize the task of classifying citing relationship by creating a two-level classification schema. We report a new metric to measure risk, and we run the first systematic benchmark of general-purpose large language models for this specific task. And our key finding is that modern LLMs are already very promising for this task, which we saw near to 79% accuracy in a zero-shot setting. And lastly, I just want to iterate that the authority validation is a critical task in daily legal practice, and we hope our work encourages more research in automating this type of task. And we also published our dataset in the link, which you can find also in the paper. Thank you for listening.
Thanks. As I said already, we're taking questions at the end. So if you have any good question in your mind, just write it down on your hand or somewhere so you don't forget it. We move on to the next paper. ContractEval benchmarking LLMs for close-level legal risk identification in commercial contracts. Shuang is presenting it and is already sharing.
Can you see my screen now?
Yes, take it
Perfect.
away.
Yes. Okay, so hi everyone, I'm Sean, and I was previous a corporate lawyer, but now I'm a second-year CS PhD student at Carnegie Mellon University. Today, I'm happy to introduce our paper, ContractEval, Benchmarking LLMs for Legal Risk Identification in Commercial Context. So first, let's talk about motivation. Just imagine a company is going to purchase a different company. How to make sure they will not run into serious legal risks? The answer is very simple. Just conduct legal due diligence. However, in this process, the attorneys will manually review all previous contracts and documents executed by the target company to investigate important legal issues such as IP ownership or share distribution. However, unfortunately, this process is very expensive for the company and also very suffering for the legal team, given the large volume of documents. Considering the popularity of LLMs nowadays, we naturally have a very good question. Would LLMs be able to automate contract review process? Before answering this question, we have to first look into why contract review is so challenging. From the technical side, the privacy concerns lead to strong preference for deploying local models to avoid uploading sensitive commercial information to online servers. Also, contracts are usually very, very long, maybe over 100 pages. This will put strict requirements on the token window for models. From the legal perspective, contract review differs from other legal tasks for two major reasons. First, the high sensitivity of missing potential legal risks. Second, the focus on clause level spans within a given contract instead of document level retrieval, such as case search. To address these challenges and also answer the question, we introduce ContractEval. In the main task, we interpret it as how to identify which substrings of a contract may or may not trigger a specific risk. As shown in the flowchart, we prompt LLMs to review contract and identify clauses as a junior legal assistant. In this way, LLMs should return only the sentences that directly address the given question, or if no clause is found, they will return no related clause. We define the research question into three layers. First, how do closed source models perform comparing with open source ones? Second, how will factors such as model size and thinking strategies will affect the performance? And third, how will the performance vary across different categories of legal risk and clause types? In the experiments, we use the CUAD dataset, which includes more than 4,000 expert annotated data points. And also, we carefully selected 19 latest models that have sufficient token compatibility with a particular focus on open source ones due to the practical benefits. Also, we use three different metrics to evaluate the performance. First, correctness by F1 and F2 scores to balance the positive and negative cases. Second, the conciseness and effectiveness by average Jacquard similarity coefficient on positive cases. Third, laziness by the rate of incorrectly returning no-related clause, even when a non-empty clause exists in the ground truth. This table shows the overall performance of 19 models, including 4 closed source and 15 open source ones. From our results, we can see, first, closed source models still significantly outperform open source ones in both correctness and output effectiveness. For instance, GPT 4.1 mini achieves the best correctness. However, open source models can achieve really good false, no related clause rate. For example, the Gamma 3 4B achieves a rate of 0. That's very impressive. And this figure shows how model size and thinking strategies will influence the performance. Generally, scaling up leads to better correctness and effectiveness, but thinking mode can only improve the effectiveness. And finally, our results also reveal that models have much lower correctness and effectiveness in uncommon or long clauses. Our results provide valuable and practical insights for the industry. So first, LLMs could perform as nearly as well as junior level legal assistants, but their outputs should still be subject to strict reviews from senior lawyers. However, most open source models still lag behind significantly, which means that they need targeted fine-tuning to improve performance. And for next steps, we will explore more evaluation systems to better align with human experts. And more importantly, we are open to collaboration. We can discuss more if you are interested. And here is a QR code to the full paper, and we will be grateful if you could let me know if you have any questions or comments. Thanks.
Thank you. It's great to see lawyers also in the workshop. I think the next two presentations are on site, and the next one, okay, it's Shanshan. Okay, you figured it out? Okay, cool. Yeah, you can come up. Yeah, just need to load your presentation. Which one is it? That's one. Even this one.
Hi, I'm Shanshan. I'm happy today to present our work, efficient prompt optimization for legal text classification with Proxy prompt evaluator. So first, some background and motivations. This work, our legal classification task is detected unfairness in term of service. Here's an example. TOS, what is term of service? So every day when we browse the internet, we just click the button like I've read and agree to the TOS and so on. I've never read that, but actually inside there can be some unfair clause to the customers. So our task is to use LLMs to detect that's a binary classification task. The input is the sentence or clause of TOS, and the LLM should classify whether it is fair or not fair. So in this problem, it's like manual reviewing. I think in the last presentation, it also mentioned is time consuming and error prone. So LLMs can help, but we know nowadays the performance of LLMs depends heavily on the prompts. So the research question is like, how do we improve optimize the prompt? So apart from the manual prompt engineering or heuristics method using in-domain knowledge, there are many works nowadays focused on the generic automatic prompt optimization method. But the bottleneck here is like, traditionally, when you have a new prompt candidate, you need to evaluate on the whole evaluation set on every step to access the performance, the model's performance on this prompt. And that can be very costly. So in this work, we focus on how to, on an efficient framework for prompt optimization with specifically a proxy prompt evaluator. So here, due to the time limit, I won't introduce a lot of details about the models or data set or metric we use. So I will just mention some high level concepts. If you are interested, please check our paper. So here, the important part is the external proxy prompt evaluator. So we have fine-tuned a LegalBird, and the input is the prompt candidate generated by an LLM, and the samples of the TOS, and that they are true, they are ground truth label. And we have the classifier to predict whether the LLM can correctly classify the this sample under this prompt. And then to use, we just use this lightweight model as a fast estimate for the prompt's performance. And our performance shows that, so in the first, that's the baseline. So the first two rows are the baseline with SVM and fine-tuned LegalBird. We see the LegalBird got the best performance, but we need to mention that that's fine-tuned on the whole training set. So we see in the zero shot of the LLM that the performance decreased a lot. But in our case, the bold last two lines, we tried with different settings with different prompt proxy evaluator. The performance do increase a bit. So though the final results does not surpass the fine-tuned legal BERT, the best performed legal BERT one, but we managed to achieve competitive performance with significantly much lower computational cost and without large-scale training. So that's our conclusion. So in this work, we propose an prompt optimization framework augmenting with a proxy prompt evaluator. And by doing so, our method can achieve a good performance, but with much lower computation cost. And we think in the future, this direction is very worth pursuing. And we suggest we can try different learning method like active learning or curriculum learning to improve the model's stability and so on. And that's it. Thanks for listening. And I'm happy to have any questions afterwards. Thank you.
Thank you. And we have one more paper before we take questions. Abhishek, right? Yeah. Which one is it? Ah, okay. No. It's PowerPoint. Sorry, I thought it's PDF, and I was trying to maximize it. You can take this, go download that, and then let me. Meanwhile, you can prepare your questions.
Awesome. Thank you. Hi, everyone. My name is Zhang Yan. I'm here to talk about using LLMs for legal interpretation. Is there a... Oh, I can just use the keyboard.
No, I mean,
turns around. Okay, there you go. Okay, awesome. So in the US legal system, ordinary meaning is needed for legal interpretation. How the ordinary speaker of US American English would interpret some legal text is used to assess legal text. And so since the advent of LLMs, they have been proposed as sources of ordinary meaning. They've also been used as citations with direct queries for federal judicial opinions. I think the argument is there. LLMs have been exposed to large amounts of data. They're easy to use, cheap to use, and they're available, especially when you compare them to traditional methods of obtaining legal ordinary meaning for legal interpretation, such as corpus linguistics or surveys. However, there's been work in LLMs-as-a-Judge literature that LLMs are sensitive to input surface form and are overall unreliable. So we asked two questions. Are LLM judgment consistent across question variation? And are they correlated to human judgment? Which is what we want. So we take a data set of 138 insurance contract disputes, which comprises of the following. In each data point is insurance contract text, a description of a certain scenario, and a set of human judgments on whether the scenario is covered or not covered under the contract. We implement 5 ways to ask the same question, reflecting known LLM bias, like the first bias, difficulty with negation words, and sycophancy, tendencies to agree with the user. So these are all the same questions, but in different form. Finally, we take 15 base and instruction tuned models in 5 families, from smaller models with around 1 billion parameters up to Llama 70B and GPT-4. Finally, we measure LLM judgment as a sum of token probabilities. In the yes/no question, the the cover probability is taken to be a sum of tokens that represent the yes judgment and the not covered, the no judgment. So we find that LLM judgment is not consistent across question variation. In this chart, on the x-axis, we have the proportion of scenarios where the LLMs prefer the covered judgment over the not covered judgment. And on the y-axis, we have the various question variants. So the inconsistency is there in both the base and instruction tuned models. It's quite large. And if you look at some of the question variants, for example, the instruction tuned model with the disagreement with negation variant, 93% of all scenarios, the model preferred responded with the covered judgment. So this allows prompt shopping, where the user is able to go through prompts until they find some prompt that is reliably able to give them the desired response, whatever it may be, and for whichever reason. We also find that LLM judgments can be moderately correlated to human judgment, as is shown in the yes/no question variant in the bottom right with the Llama 70B instruction tuned model with the R-squared value of 0.5. But sometimes they are inversely correlated with human judgment, as seen in the disagreement with negation and the negation question variants. And despite the correlation, the models might still overwhelmingly prefer one answer over the other, as seen in the agreement with negation question variant. So overall, this work adds to a growing body of scholarship in investigating LLMs as a method to obtain ordinary meaning for legal interpretation, but we're skeptical. Some LLMs provide the same judgment for most input, regardless of the scenario. There is a ubiquitous lack of consistency across question variants, not robust at all. And while we do not entirely discount the potential of using LLMs for legal interpretation, correlation with human judgment in even the largest and well post-trained modern LLMs is at best moderate only in certain contexts. That's all I have for today. Thank you for your attention. Happy to take any questions.
Thanks. So we have time for questions, and we have the microphone, which I'm going to try to bring around. Also, I'll try to switch to turn the camera around without breaking, so that the people online can see the room. Sorry, I thought earlier. Okay, any questions for either of the papers? As you saw, the theme was legal text classification, also a bit of LLMs. Yes, so I think first, and then you, and we see. Yeah, also to make it more funny, please state your name and your affiliation and your favorite color.
David Beauchemin, University Laval, blue. It's the one with the proxy prompt evaluator. What was the training corpus? It was unclear to me. How did you fine-tune the legal BERT?
You mean for the proxy evaluator? Yes. So we first run some because if you are looking for the best generated prompt, you have like a search algorithm. We use Markov chain, and then so in the first round we generate already candidates, and then we test their performance. So we use them as our training set. So we saved a lot of future search steps by doing so.
Hi, I'm Dominik Skotarczak from the Publications Office of the EU, and my favorite color is also blue. I have a question about ContractEval. How did you process the contracts? Like, what was the format of the input? Did you chunk it in any kind of way, or did you process it in one go? If you could speak a bit more about that, thank you.
Yeah, thank you. We use the existing dataset CUAD. They have pre-processed the dataset, and we didn't use any chunking. We just input the whole contract into this because in the original dataset, the contract is paired with a specific question. For instance, whether this for instance, what is like what is like the governing law for this contract? So we input the contract together with a question into the LMs. So that's why we mentioned that we carefully selected the LMs because some open source model just do not have enough token window to handle the long contract. Yeah, so that's why for like closed source model, that's not a real problem. But for some open source model, they just cannot they just cannot proceed with like very long contracts. So we didn't use these models. We carefully selected open source models that can cover the longest data set. Yeah.
Any more questions? Raise your hand, I'll come to you. Is it a follow-up or a new one? Oh, great, yeah.
A question for you also for ContractEval. From what I understand, the task that you're doing, it's right now on real life doing by junior lawyer. I think it's more of comment. It would be interesting to benchmark human competency on that task against LLM to show if there's improvement or same performance or etc. I think it would be really interesting to do that. Do you plan to do it or it's not feasible for cost or other reason?
Yeah, thank you for your question. That I agree that it's really a really good idea. So actually, that's also our future plans. But I agree that it's like it will take much longer time than the benchmark itself because one thing that we have to involve more like legal experts to do that, and also we have to carefully design how we would like to compare like the output because currently we are using offline metrics like F1, F2, or jacket similarity. They're all offline. They are not like actually evaluate the quality of the legal outputs from a professional view. And from our initial thoughts that I think like maybe a better evaluation metric would be have some senior lawyers for them to pick, for example, randomly give them some outputs from both like LMs and also from real life junior legal assistants or legal interns for them to pick which one they prefer and give me some reasons. I think that will be a better evaluation to better mirror real life lawyer choices. And we do believe that should be something we to do in the future research plans. But currently we are still working very slowly towards that. And also again, if anyone is interested in this direction, just feel free to drop me an email or talk with me. And I'm very passionate for that. Thank you.
Thanks. Any more questions also for any other paper? I had a question for the first paper, Mihai. I think I saw that your dataset was, I don't know if it was heavily imbalanced, but it was imbalanced. So can you say something about how, yeah, your models performed in that? And I don't know, are LLMs better in handling imbalances than the regular models we try?
Can you just repeat the question? Like, what do you mean by the imbalanced datasets?
In the
Effect on the
class,
performance?
in the classes, I think that, I don't know, one class maybe was
Yeah.
more,
Yeah, it is actually like the direct result of we being using a citator comparison study. So they were basically using the commercial citator services negative treatment tabs, which provides only negative treatment. So the neutral citations are only coming from lack of negative treatment. That's why we had very limited samples for neutral citations. But in the real world, not all of the cases are being negatively treated. So in the real world, it is actually quite the opposite. The neutral citations are far more common than the other negative treatments. Yeah.
Okay, thanks. Yes. So.
Changsun from Master University. Favorite color is purple. So another question also for Mihai. I noticed that you had experiments on zero-shot learning and then few-shot learning. And surprisingly, if I remember that correctly, the
Yeah.
zero-shot learning actually outperforms the few-shot learning. right?
Yeah.
Is it
Yeah, we
why is
also
that? Yeah.
we also get that question in the review process. So I would say, yeah, they are not inherently consistent LLMs. So maybe because of the we actually tried to randomize which examples we are putting in the few shot, but still probably because of the which label, which class we put in the few shot prompting, the LLM inclined to give answer from the examples, and since our dataset is kind of imbalanced, it results in a poor performance compared to zero shot. That's my diagnosis. Yeah.
Yeah. Thank you.
Yeah.
Thanks. Any last pressing questions? Otherwise, I have one question for the last paper that if I saw it correctly, you have all this correlation with the negation thingies. So why is that? Or because I thought that LLM should be better at handling negations, at least. Yeah. Any comments? Yep. Sorry.
So the question variants were designed with known LLM weaknesses in mind. The first bias, sycophancy, and also weaknesses with negation. I think is a known weakness in LLMs, and I think this is another example that demonstrates that LLMs still struggle to take into account or at least process like humans negation words. And that's shown by the inverse correlation with human judgment when the questions include negation words.
Any last pressing question? Otherwise, we'll move to the next batch of papers. And if I remember correctly, the first two are online. Sorry, we are on site. So, Seung-ho An, cool. You are ready? You're not sharing your screen, so you're not fully recording.
I'll share immediately. And great. Okay.
Go.
Can you see my screen? And yeah. Good day, everyone. My name is Hono An, and today I'm excited to present our paper, GReX for short. This work was a collaboration with my co-author, Youngi Grimm from Intellicon. Legal articles are treated as very important in many countries. Courts judges a case based on the article, and many legal AI research areas such as legal judgment prediction or legal question answering, legal article retrieval utilize these legal articles. However, some legal articles conflict with each other, which creates a confusion. Therefore, people try to identify these conflicts when drafting new laws or applying existing ones. As society becomes more complex, legislation is becoming increasingly complex, and it is becoming more difficult to people to manually find all these conflicts. Additionally, many methodologies are being proposed for regulating emerging tools such as LLM agents using rules described in natural language. And even in these applications, it is difficult to a person to directly identify conflicts. Therefore, the goal of this research is to develop a method for automatically searching for conflicts between legal articles, especially in Korean criminal law. So, how is the conflict defined? The diagram on the right illustrates both conflict legal articles and the challenging points in detecting them. In this work, conflict refers to situations in which overlapping directives or contradictory interpretation arise. For example, criminal act, I'm afraid that you cannot see the figure exactly, but Criminal Act Articles 201 and 205 are in conflict as they define the punishment differently for using opium. There are two different challenges in detecting such conflicts: high textual similarity and insufficient text. First, high textual similarity means that articles for very different crimes can look almost identical, which makes it difficult for a model to distinguish them. Second, insufficient text means that an article relies on external definitions from other articles. To solve this, we first had to formally define the problem. We introduced a new retrieval task called Legal Article Conflict Detection, or LACD. The goal is simple. Given one article, retrieve all other articles that conflict with it. Since no dataset existed for this, we built a new benchmark for Korean criminal law. This benchmark has two main components. First, an expert validate LACD dataset and the LLM-graph. The LLM-graph means the graph structure between Korean law, which consists of Korean-mention relationship. The statistics for the benchmark is on the right side. Our proposed message, GReX, tackles both challenges directly. First, to solve challenge 1, we use REX, which stands for Rerank-then-Expand. This idea is to first find a few high-confidence conflicts, then we expand our search by leveraging transitivity. Indeed, if we know Article A conflicts with Article B, and Article B is already known to conflict with Article C, then we check our Article C in our search list, as it is highly likely to also conflict with Article A. Second, to solve challenge 2, we develop the LGNN, or Legal GNN Reranker. This component uses LLM-graph to understand the full context of an article using GNN structure. This table shows our main findings. The key takeaway is in the NDCG 50 column. Our full GReX model significantly outperforms the baseline RA2 method. This is a 44.8% improvement. Importantly, we also see that both components, REX and LGNN Reranker, contribute to this success. When we use them together, they create a synergetic effect, achieving the best results. This confirms that addressing both challenges is crucial for our task. In conclusion, our contributions are fourfold. We introduced LACD, a critical new task for legal NLP. We built a new expert validate benchmark and LLM-graph to support it, and we proposed GReX, a novel method that combines REX to handle high similarity and LGNN to integrate graph contexts. And finally, our results show a significant improvement over the baseline, setting the new state-of-the-art for this task. Thank you for listening, and I hope to hear your questions. Thank you.
Thanks. We'll take questions at the end.
Okay.
So we move on to the next presenter, who is Maximilian, and which one was it? Oh, this one.
Yeah. Hi, I'm Maximilian Kreutner, and I'm presenting our work Tracing Definitions, Lessons from Alliance Contracts in the Pharmaceutical Industry. First, I want to show how this project emerged. So this was a collaborative effort with Caroline Häuser and Jörg Leusmann. They both have an economic science background and have expertise in alliance contracts. And they collected over 18,000 contracts from the biopharmaceutical industry as they were filed for the SEC in PDF format. And myself and Florian Emmerich have a computer science background and expertise in machine learning. And we were always looking for data, so the opportunity for interdisciplinary study emerged. The first task was to actually extract the data from the PDF files. Maybe I can move this. Okay. Yeah. Okay. No. Yeah, so we had these 18,000 PDFs, and we used the open source framework PyPDF2 to extract the text from them. And then we still had to get the definitions. So we compared different methods. And a benchmark was a human count of these definitions in a subset of 826 contracts. So first, we tried some sentence boundary detection tools, but we quickly found that they are not sufficient for the task. So they did not find the sentences correctly, and too few definitions were found. And we had a median error rate of 6 definitions per contract. Next, we tried regex, which exploited the format of definitions, and we found slightly more definitions than the human counts, actually. And we had a median error rate of 3 definitions per contract. And finally, we also tried a large language model, more specifically Llama 370 billion instruct. But we found that the model often hallucinates new definitions. So it finds definitions that are not even part of the contract and gives them back as if they were. And we found a median error rate of 4 definitions per contract. So because of this, we stick with the regex, and in total, we found 380,131 definitions from 12,000 different contracts, ranging from the year 2000 to 2021. And we also were able to directly define the definiendum, so the word that is being defined in the definition, and the definiens, which explains the definiendum. Next, what we wanted to look at was the similarity of definitions. For this, we used 2 transformer-based embeddings, general text embeddings and expert embeddings. And first, we wanted to see how similar is one definiendum defined across all different contracts. So we took the definientia of all definiendia with the same definienda. And what we found is most similar are usually legal terms and organizations. They are very well defined in each contract and basically don't differ much between the different contracts. Less similar are social terms. So for example, the collaboration or diligent efforts definitions. And least similar are the definitions that are specific to each contract, which makes sense. So for example, party, which is part of the contract. The takeaway from this is that partners should focus their attention on social terms because they might be different in each contract, and we will later see why this is important. Second, we also wanted to see if we can find definienda that are very similarly defined but have a different name. For that, we took the mean embeddings for all definientia of one definiendum and then calculated the similarity, the cosine similarity between those embeddings. And this allows us to connect high similarity definienda as a graph. So for example, what we can see is the cost of goods and cost of goods sold and manufacturing costs and manufacturing cost are very similar defined, but have different names in different contracts. And this might assist partners to avoid unnecessary equivocality because they don't have to use different names in different contracts anymore if they use this. Second, we also made a quick case study to show how we can quickly find unusual definitions. So there was a huge lawsuit between AstraZeneca and the European Commission in 2021. And at the center was that both parties disagreed what best reasonable efforts actually means in their contract. And we analyzed this definition and compared it to other definitions which contained the efforts clause with a pairwise cosine similarity again. And what we found here is that first of all, best reasonable effort itself, the definiendum, is highly unusual. So commercially reasonable effort is way more common. We only found 3 definitions in total that had best reasonable effort. And out of the 1,512 definitions that we found, 1,346 have a higher similarity score. So this definition is highly unusual. And this method could allow alliance partners, if they form a new contract and write a definition, to quickly get an overview of how different the definition is and maybe determine risk of including that definition. Also, we looked at the temporal patterns. So first of all, the amount of definitions in contracts. First of all, we found that Most contracts have actually been signed between 2006 and 2008, which was during the financial crisis. So we can see these global events being reflected in definitions. We also see that there's a consistent increase in definitions per contract over time. So each contract each year contains usually more definitions. And we also see that all definitions appear more often. Finally, we fit a per topic model to see the topics that become more important or less important in the definitions. What we've seen is that technological definitions about the product have become less common, but stock and shares definitions are more prevalent compared to other definitions. And one possible reason could be that there is an increased merger and acquisition activity in the biopharmaceutical industry. So there are a lot of contracts that have to define the new stock when a company gets merged with another. Yeah, so contribution is this new data set with 380,000 definitions. We combine an interdisciplinary approach, so we use these common NLP methods with qualitative analysis to get more insight. And the limitations are that the extraction from PDF can still be noisy, so some of these definitions might be a bit noisy, and some definitions from contracts might be missed by the regex we used. Thank you for your attention.
Thanks. Write down your questions for the end. We still have 3 papers, and the next presenter is already ready, Sai, so you can share your screen and start.
Hope my screen is visible to everyone. So myself, Sai Khadlaya from Adalat AI. The paper I'm presenting is CourtNav, voice guided anti-accurate navigation of long legal documents in courtroom. So the problem that we are trying to solve is the massive case backlog of Indian judicial system. Judges rely on keyword search or memory when finding the correct references in live code settings, citation reset, annexes break, numbering, and scans loop structure. The human context lens is actually determining justice rather than the arbitrary truth. Manual navigation averages 3 to 5 minutes per reference, and the problem is Control F, which does not work in the scanned documents, which cover the majority of the Indian legal jargon. There is no accurate way for judges to verify the information or arguments which are made in the live court setting, leading to fundamental risks to the justice system, adding to the infinite delays and backlog. So how court navigates today is doing control on the documents which are not scanned and which does not work. And how ideal or what we inspire the navigation to feel like is hands-free, voice-driven, grazing fast. So let's say the judge says, highlight the contradiction in PW2's cross-examination, and the system jumps straight there. So it's grounded, auditable, and non-hallucinable. So there is no summary or paraphrase, only verifiable text, which is anchor guided. So a voice-grounded system. So the architecture, how it works is we have a voice input. There is a ASR speech recognition device, which is a fine-tuned whisper, which is trained on Indian legal jargon to support hands-free navigation. Then there is a router. So the query router is there in place because we understand that not all queries can be handled similarly. We have 3 types of queries: temporal query, direct navigation. There is no embedding overhead or contextual overhead. For example, go to paragraph 23. Contextual queries are queries which could be solved by, let's say, parsing dense retrieval. Semantic keyword queries, semantic queries or keyword queries. There is a summarization-based queries. Summarization-based queries, we are defining queries which are not direct hit matches, but require the entire document understanding. We have a very novel way of trying to solve that problem. We solve this problem using sparse and dense retrieval with contextually enriched chunks. So we add to every chunk the information why this chunk exists at this particular place in the document. Because in a whole, in a legal document, the chunks do not really mean anything. So this stage, after the retrieval, there is a viewer or a reader. The reader model is the language model which abstracts the responses. We chose a very null choice using a coding model instead of any general model, let's say general abstractive model. So the novelty behind choosing coding models is that they are specifically trained to reference and reason over specified context, edit over specified context, and cite relevant things and ignore the unnecessary. That's the training regime. We use a transfer learning based approach here. Here are the improvements. Here are the results. So so for efficiency improvement, we are comparing how manual navigation and voice-driven system works. The manual navigation for temporal queries which are like go to paragraph 23, are lawyers. So we had a set of blind lawyers who just evaluated the system without knowing anything at all and the documents at all. They take 10 seconds on an average to navigate to, let's say, some paragraph, while our system reduces the time to 5 seconds. They take about 200 seconds to find the correct document by correct paragraphs by control F search, which we resolve to 6 seconds. And summarization based queries, like which require the entire document understanding, takes them on maybe hours or days on average, we solve in 6 seconds as well. We had our internal benchmark and we tried to measure two things. One is the average precision and other is the trigram recall. We get the average precision reaches as high as 0.6 with our layout aware contextual method, so contextual chunking, and using a very good open source reranker, which means that there is a very stable and thresholdable ranking for the leader language model. We also see tremendous improvement in hard recall after the retrieval stage, seemingly solving the impossible retrieval problem as well as with our novel layout aware chunking. We have a custom defined metric which is legal noise sensitivity, because we understand that legal data is very sensitive and we cannot hallucinate on this. So, and since we are using a RAG based approach, there is always a chance of noise or hallucination. The way we solve is this following metric. Let Q be a query, R is the retrieve context, and G is the goal context, and RP is the model response. We define noise sensitivity as the faithfulness of the response with respect to the ground context, divided by the faithfulness with the retrieve context minus faithfulness with the ground context. So the assumption here is that all the response could be faithful to the ground context itself, and the retrieve context as a whole adds no new information. So this is the noise sensitivity metric. The danger zone is 0 to 1, because in this range, it means that the retrieve context has more faithfulness to the response, and the response is hallucinated a bit, and it's not entirely from the ground context. We see that our coder model achieves the lessest minimum noise sensitivity in this range. The other ranges do not really matter to us because this is the danger zone. So we choose the coder model naturally. We evaluated on several state-of-the-art models, including Commanda, which is a RAG answering model, GPT 4.1, which is a frontier model, long Citations, which is also trained to cite things and work like that. And the Quen 3 still shows to be a best model in this regards. Following is the deployment note. We do on-premise deployment of all model in the Courtrooms. No data is logged, no data leaves our server, touches foreign servers, no third-party API usage. Super efficient and decoupled system design with custom patches added to model to support open source inference provider. User data is transparently deleted as soon as they click the delete button. There is a novel per query online retrieval thresholding. So what we do is for every query, we calculate how many chunks to retrieve rather than fixing, let's say we want to retrieve top 20 chunks, or we retrieve, let's say, all chunks which are greater than 0.5 in similarity. This prevents the noise sensitivity problem because the probability of hallucination becomes null since we are not really retrieving anything which is not really necessary. We benchmark this as well. All data is verifiable and interpretable directly from the highlights and anchors. If there is no anchor, there is no answer. The broader impact. So CourtNav is part of Adalat AI's effort to make every courtroom AI ready. This is not a small UX chip in our thinking, not just a way to navigate faster, but will serve as a way to verify argument and provide fairer and timely justice in live court setting. Justices no longer need to rely on the facts which are presented to them. The facts will be actually facts which they can verify and see in the navigable live anchors. This is how the system looks today, by the way. So there is a document that you upload. We give a summary. This summary is calculated on the basis of the entire document completely. It's abstracted. And let's say the person asks, why does the court hear both applications together? We answer and we cite properly. You can see that the citation itself is very layout aware. There is no extra thing being cited. We have made sure that the citations themselves are remaining paragraph level so that all the information is there. Thank you.
Thanks. And I think I saw the next presenter also is ready to take over. So when you are ready, share your screen and
Hello. Good morning, sir. Is my screen visible?
yes, also you might want to speak up a bit because yeah.
Okay, so good morning, everyone. I am Siddharth. I'm a third year undergrad from India, and I will be presenting our work NyayGraph, a knowledge graph enhanced approach for legal statute identification in Indian law using large language models. So one of the first steps in the judicial process is finding the applicable statutes or laws based on the facts of the current situation. So our research focuses on improving the task of legal statute identification, one of the most foundational steps in legal automation. We present a novel graph-enhanced approach for LSI in Indian legal documents using LLMs, incorporating structural relationships from Indian Penal Code, IPC, the main legislation codifying criminal laws in India. So the main challenge, the problem, which is India currently faces over 44 million pending court cases, which severely impacts access to timely justice. A key bottleneck is identifying the correct statutory provisions from lengthy case facts. So the LSI task, legal statute identification, aims to map narrative text to relevant legal sections, but Indian law poses unique challenges such as extremely long and complex statutes, frequent cross references, sparse data sets, and often an LLM often hallucinate or miss structural relationships. So our goal is to embed the actual structure of law into the LSI pipeline. So our core idea is like our contribution is simple but powerful. So large language models alone do not understand the structure of the law. So we explicitly provide that structure using a knowledge graph of the Indian Penal Code, the IPC I mentioned earlier. This KG acts as an external verifiable knowledge source to guide retrieval, expansion, and inference. So how we build this KG? To build this KG, we extracted the structure directly from the official sources like the National Crime Records Bureau, the NCRB reports. The graph contains 1,225 nodes and 2,600 relationships. So it consists of mainly 5 types of nodes. That is the chapter section. Chapters are the chapters of IPC, sections are sections in the particular chapters. Then section description, and the IPC crime heads and IPC subheads are from the NCRB report I mentioned. Then there are 8 types of relationships capturing the all the hierarchies, criminal classifications, cross references, and content links. To our knowledge, this is the most detailed structural representation of the IPC built so far. LLMs trained on text only learn patterns, but law is not just text or sequential. It's a graph of dependency, especially the Indian law. For example, a section might cite 6 other sections belong to a chapter and map to multiple crime categories. By traversing these links, we recover relevant statutes that semantic similarity alone cannot detect. So the graph only inference results. So we first inference the graph only. We ran a purely graph-based inference pipeline on the IL2 dataset, which is the like benchmark for Indian legal domain. The improvements were substantial. Like as you can see, the 136.8% recall improvement at k is equal to 10. K means the top k sections retrieved from the knowledge graph. So we took different k values, k5, k8, k10. So at k10 we gained the recall of 136% and hit rate improvement by 136.5% and map improved by 42.3%. So this clearly shows that structural relationships dramatically increase the coverage and recall even without an LLM. Then the next step was the LLM plus KG pipeline. Next, we incorporated the KG into the retrieval augmented LLM pipeline using Llama 3.18 billion model. The pipeline worked in 4 steps. The semantic retrieval of the relevant sections using the NLLP model. KG expansion using the citations plus crime subcategories like the into the KG, the next sections which will be cited in the KG will be retrieved from here. Then we constructed the prompt and then the LLM scoring and prediction of the IPC sections. LLM plus KG improved recall compared to vanilla LLM, but the micro F1 score dropped due to false positives introduced by the aggressive KG expansion. This highlights the need for re-ranking. The insight was important. The knowledge graph significantly improved coverage, but coverage must be controlled with strong re-ranking to improve our accuracy. So think of a KG like a recall amplifier, but the re-ranking as a precision filter here. So what the next steps we should take, or what we have planned, then that is the first is we can train a learned re-ranker that combines the LLM scores with the KG derived features like citation degree or shared crime rate to reduce the false positives and from naive expansion. Secondly, we can of course expand the KG with the other acts and CRPC, the crime penal code, etc. In India, we have various kinds of laws for different categories and all. Third, we can systematic ablation experiments as mentioned in the PPT. Then, however, the major constraint which we faced were the resource limitations at my institution particularly, and hence we cannot run or fine-tune different models. Like we just use one model that is 3.18 billion due to limited GPU availability and no financial support for cloud APIs like OpenAI or Cloud or etc. In fact, the amount to register this paper in the conference is also from my personal funds. So this is why we restrict ourselves to only a single model in our use case. Fourth, we can use the human in the loop validation to verify our results and all. So in conclusion, like I can say ki we created a reproducible, fully verified IPC knowledge graph and integrated into an LSI pipeline, demonstrated substantial coverage and recall gains, and identified next steps needed, that is re-ranking. This work brings us closer to building transparent, interpretable AI system for law where every prediction is grounded in statute structure. Thank you.
Thanks. Okay, we have one more presentation, so I hope you're preparing for your questions. I also see the last presenter ready, so if you you can share and start, and try to keep it 5 minutes. I'm terrible with time tracking, so I rely on you.
Sorry, just give me 1 second. Sorry, 1 second. I'm gonna need to leave and come back in order to share. I'll be really fast. Sorry about the difficulty.
Okay, suddenly we have some time maybe for the for questions from the other speakers. So is there some question for the first 4 papers? Or you're back already?
Yeah, sorry about that. I just needed to enable a setting. Should be able
Do you want to do?
Yeah. Okay. Can you guys see my screen?
We see your screen. Yeah, we see your presentation. So yeah, you can start.
Right, cool. So hey everybody, my name is Keshav Karthik, and our paper is titled Beyond the Haystack: Sensitivity to Context in Reference Recall. So this paper was made possible by the AlgoVerse AI Research Program, where I worked with Karthik Srikumar and Advait Ranjit. We're all high school students. And I worked with my mentor, Eric Chia, who is a bachelor at Brown. And we also had help from our program directors and our PIs. And all of us worked together to make this paper possible. Okay, prior research. So in the past, to assess LLM long context recall, the needle and haystack evaluation, or NyayGraph, has often been used. And this is where a short string is inserted into a larger window, and then language models' performance is measured on how accurately they're able to retrieve this short string. However, in our paper, we demonstrate that performance metrics from NyayGraph are actually not generalizable to specialized domains like law. And in existing work, we see that retrieval and reasoning is conflated, and a lot of existing works don't properly address potential data contamination. Our research motivation is we want to understand LLM reasoning in standard long context benchmarks. This will allow us to differentiate benchmark and specialized domain performance, and thus advocate for the importance of new long context benchmarks. Our approach. So we chose a cutoff date of July 2024, and we selected 5 models that were trained before this cutoff date. And additionally, we used Court Listener, which is a database of legal cases, and we used the API to extract cases after our cutoff date. And we did all this to ensure that the models have not seen the cases beforehand. So for each model, we gave needle tasks and recall tasks, where the needle tasks occur when the text is completely shuffled, and the recall tasks occur when the text is standard. And as you can see from the diagram here, the models seem to do significantly better on the needle tasks than the recall tasks. Additionally, we performed shuffle tests with varying shuffle windows to examine how surrounding context plays an impact in LLM reasoning. And we also did needle position ablation tests to understand how much of an effect position plays in LLM decision-making. So this table essentially outlines our recall tasks that we did. So we did 3 recall tasks: decision, author, and citation. And for each recall task, the model was given a binary prompt and a needle, and it had to identify whether this needle was present in the document. So our main result is this distinct J-curve that came from our shuffle tests. As you can see on the x-axis, we've plotted shuffle window size in words, and on the y-axis, we've plotted accuracy. And for local shuffles from 0 to 5 window size, we see that the model accuracy reduces to a minimum. And we hypothesize that this is because the model is still in what we call reading mode. This is where the model is still using surrounding context, specifically sentence-to-sentence cues, in order to make decisions about our prompts. However, after a shuffle size of 5 words, we see the accuracy start to go up as global shuffles are reached. And we hypothesize that this is because the model goes into recall mode, where it is only employing pure retrieval because semantic coherence has been completely disrupted. This makes accuracy rise up to a maximum. Additionally, our position and ablation tests showed that needle position cannot explain the discrepancy we see here, as there was little correlation between position and accuracy. Here are some other results that we found. On the left, you can see a graph of case word count on the x-axis and the error rate on the y-axis. We plotted this for standard and NyayGraph evaluations. And as you can see, the standard error rate is higher than the NyayGraph error rate, with the gap between them increasing as case word count increases. This shows that current long context benchmarks are unreliable when it comes to specialized domains. And this is further supported by the graph in the right, which also shows error rates, but for each individual model, with the blue representing the NyayGraph error rates and the green representing the gap between NyayGraph and standard error rates. So our key limitation was that there could be a possibility of other unknown internal LLM mechanisms that influence performance. Thus, we are unable to claim that the J-curve is fully responsible for model behavior, and we invite future studies to examine model internals and perform attention analysis to verify our results. In conclusion, our paper highlights that standard benchmarks overestimate recall, and we see that this is because of contextual informity, as you see from our J-curve, and we highlight the need for specialized testing in reference-critical domains like law. Here are our key citations. You can find our full list of citations in our paper. And yep, that's it. Thank you, everybody, for listening.
Thank you. So now we have time for questions for all 5 papers. I will turn the camera now that I know how to do it. Great. So questions, raise your hand and I'll come with the mic to you. Yeah, Chang.
For the speaker, kind of, right? Yeah, sure. Okay. Yeah, my name is Chang Sun from Master University. And first, I would like to give compliments to the last presentations. Was surprisingly, they were high school student. Right. That was very impressive. So my question about like this outcome that you probably listed in the limitation, that I wonder whether the different LLMs give you different outcomes, whether this, what is your hypothesis? The internal structures of the LLMs actually play a big role in it.
Yeah, so first of all, thank you for the compliment. I appreciate it. As for the generalization, so we have seen this phenomena across other models, but you are completely right. There could be other internal mechanisms that influence the model. If we perform deep analysis, we could further investigate those mechanisms. But this is a little bit more of a surface level analysis of what we observe about models' behavior. But you are completely right. Yeah, that is definitely a limitation from our findings.
Did you also try different sizes of different models, or you only just like how those models being selected and whether they are systematically being selected, or you just, you know, pick the models that you can use?
Yeah, so we selected 5 models, which actually have a variety of sizes. So the 5 models that we chose were GPT-4o. These are all models that have been trained before our cutoff date. So the 5 models we chose were GPT-4o, Gemini 1.5 Pro, Claude 3.5, DeepSeek V3, and Llama 3 8B. So these models vary in size and diversity. So that kind of gives us like a full breadth of results and shows that we can generalize our findings.
Thank you very much.
Thank you. Yeah, I'm coming. Since you haven't asked before, you need to go. Yeah.
Okay. Hello, my name is Max Brio. I'm from the Technical University of Munich, and my favorite color is orange. So I have a question regarding the tracing definitions lesson from Allianz contract in the biopharmaceutical company. Yeah, industry. So maybe you said it already, but you said that PDF extraction is noisy. So I'm asking because I had the same problem with my paper. Which tools did you use, and do you have any insightful advice to fix this problem? Because I didn't get the text out that well.
Yeah, thank you for the question. Yeah, it's actually really hard to get the text out of PDFs. So the PyPDF tool gets the text out of the PDF, which is like really noisy and unstructured. And I think it's harder to get specific text that doesn't have a specific format, but helped us here a lot was that definitions always follow a certain kind of format. So the regex actually worked really well to define where the definition starts and where it ends. You can read about it more in the paper if you want. In general, there has been a series of shared tasks in SPD. Maybe you can check that out. Maybe that helps for your paper as well. Thank you.
Yes, it's a question for you, actually. Have you tried to test with larger model? Because I recall right to try only Llama 70B. Have you tried like reasoning model? Because from my experience, it's better for definition and stuff like that. Do you plan it, or is it just a problem of accessing the fund to get to train and test that?
Yeah, thank you for the question. So at the time that I was doing this, there was a lot of research that tried this in other concepts. And it found similar things, that the models hallucinate a lot. So we only tried this and basically found the same thing in our context and then said, okay, we keep it as that because other research supports this claim. I think there has been a lot of progress in text extraction with bigger models and newer models. We haven't tried those yet, but I agree that it might be really interesting to do.
Cool. Any other questions for any of the papers? Otherwise, I have some short questions myself for the remaining papers. So maybe for the first paper, because you kind of introduce a new task, which is not really a new task because it's a retrieval task. So, but I was wondering, given your results, which I try to take note, but I'm not sure if they're correct. But like, let's say the recall at 50 was like 32 or something %. So how high you want recall at 50, let's say, to be good or considered good, or any thoughts on that, given that it's a retrieval task, but as you said, it's like a bit differentiated as a task.
So I understand the original question is about how my method can increase recall that high, right? Basic concept is that the trivial retrieval processes consists of two different steps, which is first retrieval, some searching some candidates and re-ranking the candidates so that make sure that may return more high quality results, right? My idea is that we somehow utilize re-ranker as a improving step one's candidate's quality. So the expanding process is kind of utilizing re-ranker as a improving methods for the first steps candidate. So I think that is the key point and takeaway message for our methods.
Thanks. And then maybe very shortly for the NyayGraph paper, if they're still online. Yeah, so maybe very shortly, because you have this nice knowledge graph derived features. And I'm wondering, like, do you have any idea which might be more important or more, let's say, critical for, finding, let's say, relevant statutes? Or did you have a ranking, let's say, which might be better or might rank higher, let's say?
I didn't get your question exactly, sorry.
Like you have these specific graph features, like I tried to take some notes, like the shortest path length or the shared crime head flag, right? Or the citation degree, right? Do you have any idea or maybe what you anticipate or you expect from your analysis, which can be more, let's say, important or more critical for your task? Or
Yeah, so this we planned for our as a future work, since all these heads which we took were from the government sources. So we cannot like change or manipulate something in those. We can just add this to our analysis. Your point is absolutely correct. We should have done this analysis too.
okay, yeah, I mean, I know it's future work, but I was thinking if you had any perspective, but yeah, fair enough, fair enough. And then maybe for the CourtNav paper, which was like a refreshing new application, but I understand that there are ASR errors, which are kind of, do you have any idea why they might be caused, right? Is it dialects, is it accents, and how significant they are affecting the system in the end?
Right. So for Indian legal system specifically, ASR errors come due to low network latencies and accents and dialects majorly, because in 29 states across India, every state has a different accent, and we try to model everything together. So this is why the way we perform is we do annotated data collection from every state area, and we make them speak that legal data and then fine tune the whisper based on that. The objective is to minimize the word error rate, and we do some inverse text normalization processing as well, based on the common legal accepted thing. Nothing LLM based, or no hallucination. Everything is regex or plain text based. So this is the way we try to reduce ASR errors. still there is an option to edit whatever you spoke. So ASR errors can be corrected by the human itself if necessary.
Okay, thanks. Okay, thanks all. We are only 4 minutes late, which is something to appreciate. Before you flee, have some sort maybe housekeeping announcements. So now there is lunch, wherever lunch is supposed to be, and some of you have brought posters. I'm not sure what the numbers are. They should be somewhere up in the screens, or that's what they told me. So we'll figure it out together. So have some lunch and also visit the posters. I still have, as I said, stickers like merch from the workshop for the groupies, so you can take some. And yeah, wait, I can share it also as a reminder. So we ran a Best Presentation Award to be announced at the end of the workshop as a motivation to stay here and stay engaged. And both sponsors, right? And also because we have lunch from the conference, we plan to go for a dinner later on. So now is the time to get your vote or your participation in Hoover so that we can get a number and we can get the details. So yeah, that's it. So we're back at 2. Don't be late. Also, maybe the presenters of the NUT session come a bit earlier so that we check the logistics. Otherwise, have a good lunch. And yeah, don't forget to visit the posters. Thank you. It depends where you send them. You can send them to the workshop email or yeah.
Send to
So the email. Yeah, and a PowerPoint or PDF.
Send to who?
To the address of the workshop, right? So the one that you got the information. So yeah.
Is from NLLP or is from EM?
No, NLLP, the workshop, right? Or you can present from your laptop if you have your laptop. Or okay.
I will do both. So
Yeah. Okay. Yeah.
I think we should add a pool for vegetarian.
Maybe. Yeah.
I can remove it.
I don't know how to do.
Yeah,
Well, I do, but yeah. I mean, yeah.
I will just add.
It's in the meetups. Yeah. This will stay on, right? Because like the main organizer went to sleep because in the US. So yeah, I mean we need to have host, right? Yeah.
Hey, uh, can you hear me?
Yes,
Yeah.
we just wait a bit because yeah, people are still coming back from the lunch break, so I guess you are ready, but yeah, maybe we wait 1 to 3 minutes so till people come back.
Here, let me know when you're ready.
Meanwhile, I think I see Tuba as well and Marcus. Is there somebody for the GuRE paper, the generative query rewriter? Okay, and then the last paper, the colleague, which is findings. Cool. You did what? Did we plug it in? How did you load it? Did you send me? How did we? Somebody is in the switch. Okay, I'll switch for that. So we can find a switch to the back end. No, I mean, because of that, because we just moved it for the questions, but then it only embedded from here to there. So yeah, but yeah. So now it works.
Yes. Yeah.
Okay, given the time, I say that we can start the afternoon sessions. So we have two blocks of 5 and 5 papers, and we will have first the presentations and then take questions for either of the 5 papers. The first batch of 5 papers is also revolving around retrieval and RAG. So that's the general topic. And I think the first presenter is already there and ready to take it away. Just share your screen and yeah, try to keep track of time because I'm terrible at it. So just 5 minutes and then we move to the next one and we take questions at the end.
Yeah, thank you. Can you see my slide?
Yes.
Hi, everyone. I am Asiful Islam. So today I'll be presenting our work, a framework to retrieve the relevant laws for will executions. So the validity of a will depends on the statutory laws of a governing jurisdiction that apply to each of these will statements. And the first step in assessing the validity of the will is to retrieve the statutory provision of each statement in the will. Currently, legal professionals perform this lookup manually, and this manual process is slow, costly. And there are no existing system that automatically retrieves the relevant laws. So by motivated by this gap, we introduce a framework that automatically retrieves the laws relevant to the validity of the will statement. And so our task is given a will statement and a relevant conditions, retrieve the relevant laws that can either support or refute these will statements. So to solve this, we propose a RAG-based solutions, and the first step of this RAG-based solution is extracting the relevant laws of this jurisdiction, and then convert these laws to two index, one inverted index and another one is semantic index. In our case, inverted index is just a mapping from law terms to law codes, and we use Elasticsearch to do that. And the semantic index is just a vector embedding mapping with each of the law codes, and we do it like a transform-based encoder, which is ASBERT Legal XLM. And the next step, which is the top K candidate retrieval, there are two searches here. One is lexical search and another one is semantic search. Here, lexical search is just a BM25 of base scoring of all the laws. And the semantic search is cosine similarity based scoring of all the laws. So we take this two scoring and two rank list, and then we combine this rank within a concept called reciprocal rank fusion, which just aggregate the result from multiple retrieval systems. And from this aggregated rank, we take the top K, and this top K most relevant law, we give it an LLM as a context, and we create a prompt using instruction, which is the task description and will statement condition and the context, and ask the LLM to extract the most relevant top one most relevant laws. And for experiment, we created two datasets, one from two US states, one is from Tennessee and another one is from Idaho, and we collect all the state code from Tennessee and Idaho. For will statement, we use the US will and probate dataset, which is a publicly available dataset. And we asked some annotators to annotate the relevant laws, one which is supporting and another one is refuting. And we asked also them to add some hypothetical condition that may impact the validity of this will. The first result shows the performance of the top K candidate retrieval. We compare three methods. One is independently using lexical search, another one is semantic search, and then combining both of them using reciprocal rank fusion, which we propose as our proposed method. And we try for different K values and shows that this hybrid search outperform both lexical search and semantic search in all the cases in both Tennessee test set and Idaho test sets. So then we use K equals to 20, and then we use this top K candidate values with some LLMs. We try with the open source LLM like Llama and also legal LLM like Sol LLM and various variation of the GPTs. And as a baseline, we use the zero-shot version. That means we do not give any candidates. And for our method, we use the hybrid method where we give a top 20 most relevant candidate laws. And it shows that the performance of the zero-shot method is very poor. For example, this Llama, the performance is only 3.17%. But if you use our RAG, the performance boosts to 47%, which is almost a 44% improvement. We can see the similar performance improvement for the Sol LLM also. And for all the GPT variants also, we can see an improvement. So in a conclusion, we hope our work will support the legal professional in retrieving relevant laws for will validity. And also, we hope this work will lay a foundation for future research that aims to automate the will validation process. So if you have any question, I'll be happy to chat during the QA session. Thank you, Björn. That's all from me.
Thanks. And I think we move on directly to the second presentation. I see Tuba is already sharing her screen, so we can also see the screen, but yeah, so
Okay, can you see the screen now? Hello.
yes.
Okay. Hello, I am Tuba Gökhan from MBZ UAI, and today I will share our work related with regulatory RAG system. Oops. Regulations are very similar with legal domain, and generally all related obligation and rules distributed from many different documents or many different sections. Typical RAG system assumes that one passage generally is the best, but it is actually not. Then in that paper, we focus on multi-passage regulatory system, but in that case, we have a problem reaching about a data set. For that, we generate a synthetic data set. And then first we generate a data set. Second, we train a model for re-ranking. Then we generated answer based on some obligation-centric prompting. Then in our ObliQA dataset, we started from original ObliQA dataset, and we keep only multiple candidates. It was around 13,000 question and pairs. Then using LLM, we annotated them as a direct, indirect, or not connected. And we keep only question has at least 2 connected passage or at least 1 direct passage. Passage means, by the way, rule or obligation. Then we remove weakly supported passage. As a result, we have around 3,000 question answer pair. In our RAG system, we apply 4 steps. In the first step, we candidate retrieval using different methods. We took hundreds or 200 passage. After that, we extract features has 4 different group: lexical group, retrieval group, graph-based group, and neighbor semantic groups. Then we generated some feature vector. We trained our feature vector for re-ranking. After that, we apply a score-based filtering approach, and we generated answer based on the grounding citation. In here you can see our which feature we use. For lexical, we use a simple approach, unigram, bigram, etc. For graph-based feature, we develop a system. We keep hierarchical info for all related passage and section and documents. Based on that, we extract some feature and we use some retrieval fusion trained model. Then in here you can see one end-to-end sample question related with risk management and reinsurance risk. Model retrieve 4 different passage, and we combine that passage. Citations are will be here. We know IDs, where is coming where, and it can provide a traceable answer structure for compliance officer or any person wanna need information. In here you can see some result. When we apply first OBLIQUA baseline approach on our OBLIQUA MP dataset, performance drop very sharply. Then we develop our in table 4. You can see that our learn to rank model improved the performance very well. And then also this improvement and grounded citation-based answer generation improved the general answer generation quality. And of course, we have some limitation. First thing, our data set is fully based on the LLM. It is fully synthetic. It can create some missing details. Also, in the future, we would like to develop more hybrid approach and more evaluation metric for that domain, for that problem. Thanks a lot.
Thanks. And okay, next presenter already shares their screen. So yeah, I will just start and I will take care of the Zoom.
Apologize about my environment. I mean, my sister wedding in South Korea, and it can be a little bit noisy. So if you have anything confusing, then you can email me from the paper. So I will briefly start my presentation. Okay. The paper is GuRE, and the name of the GuRE is from here. This is the name of my dog, GuRE. Is pronounced like GuRE like this, and it is a cute word for raccoon in Korean. So I made my title of my project like this, and I'm targeting the vocabulary mismatch by reformulating the query for retrieval accuracy. So here's a I will switch to okay, I will do like this. The main challenges are like this. Legal professionals spend considerable time searching for relevant passages due to the cases contain lengthy and complex documents. So we require the fine-grained information like passage level retrieval. However, most research focus on the full case document level retrievals only. So, and the other problem is the input retrieval query, and the target passage has really big vocabulary mismatch, which can hinder the accurate retrieval. So our target is to mitigating this vocabulary mismatch through the generative idea. This is like rethinking the task from the retriever, which is a discriminative test, to the generative test like generation. So here is the simple idea for this. We use LLM, which the manner, autoregressive manner. We fine-tune the LLM from query to generate the target passes, and then we use the generated rewritten target passes as a retriever query. So here are the comparison of the other base rights. This is a vanilla, and this is most popular query reformulation method, which add more context to find better documents. And retriever fine tuning is one of what suggested one from the previous research, and this is our approach. Our approach don't train the retriever, so this can be plugged in to any method like this. And we experimented the data set for this left part, which contain US federal precedents in various sizes. And precedent had the long tail distribution, which means top 1% passes has about 18% of citations, which has a lot of imbalance. And here are the main results. And our method can significantly improve retriever agnostically with sparse and dense retriever both. And even we perform better than direct retriever fine tuning. This was very interesting to us. So we further did analysis about the reason, and most retriever fine tuning is done by this kind of self-supervised contrastive manner loss, and that can hinder the discriminate the same label texts. Because, for example, when we set the batch size as 100, and there can be 80 same label citation documents, but this loss cannot discriminate the 8 labels each other. So that can penalty to the popular citation. So the behavior of the loss by the sampling threshold can be different like this. So our method is much more applicable in the real world application than the retriever fine tuning. So here are the conclusion and future work, and maybe I ran out of my time, so you can check from the video. Thank you, and these are the photo of the GuRE, our project. And I apologize. I should left from this workshop because my sister's wedding start in a few minutes. So please forgive me, and I hope anybody in this workshop can email me. Thank you.
Thanks. And we move on to Marcos and colleague, I assume, who are up quite early in Europe.
Yes, it's Europe. Hi, I hope you can see my screen. I'm really delighted to present you our paper with the topic Towards Reliable Retrieval in RAG Systems for Large Legal Data Sets. My name is Marcus, and beside me is my co-author, Toby. So let's start directly into. Due to the time constraint, we need to assume that everyone is familiar with standard RAG, because RAG allow access to external knowledge in the retrieval for an LLM and reduce hallucinations. However, the retrieval part of RAG systems use standard chunking like fixed size or semantic chunking, which breaks the document into isolated pieces. And this discards the global context of the chunk. And it is especially a problem in legal texts which has characteristics like structural similarity and standardized language. So in the end, many chunks probably look very similar in the database. As a result, the retriever might pick chunks from entirely wrong contexts. We want to quantify this phenomenon and did so with our metric of document level retrieval mismatch. This measures the percentage of falsely retrieved chunks that originate from completely incorrect source documents. And the result for this metric are in the figure, where this metric is catastrophic for standard chunking, with up to 95% of the mismatches for our legal data sets. So what we did, our proposal is called summary augmented chunking, and the idea is to re-inject the global context into every chunk. As you can see here, the document is first chunked into pieces as it's usually done by standard chunking, but also we summarize each document and prepend the short summary of a document to a chunk, so that we have a whole summary augmented chunk, which has a global context, and we index this into a chunking database, which can then serve for the retriever. The advantages of this are clear. It is efficient, so only one additional LLM call per document is needed to generate the summary, and it's also modular, so it's really easy to integrate it into existing retrieval systems. So what does the result say? On the left-hand side, you can see standard chunking performance again, and on the right side, you can see our method. Summary augmented chunking essentially halved the document level retrieval mismatch, which was a pretty interesting result to us. But now we wanted to see if our method can also achieve good results on a text level metric, where the task is not only to find the correct source document, but also the correct ground truth snippet within one document. And this is what you can see here. Depicted here is the precision and recall of the correct text snippet compared to a ground truth snippet, where the purple line on the bottom is the standard chunking, and the green line on the top is our method. And it can easily be seen that our approach achieves, again, also a better result on the text level. So the first key takeaway here is that with a relatively simple solution as our summary augmented chunking approach, it is possible to achieve significantly better retrieval quality. And as a last step, we want to improve the results even further by integrating expert knowledge from our legal experts in the team. And what they did, they designed a summarization prompt, which should extract highly discriminative summaries for each document. And the result for this can be seen in the yellow line. Interestingly, those expert prompts could not outperform our normal approach with the generic summaries, and we refer to the papers for reason of this phenomenon. So let me just conclude really quickly. We introduced summary augmented chunking, which provides global context to chunks in an efficient and modular manner, and it leads to significantly improved retrieval results in our benchmark. In future work, we would like to explore hierarchical chunking for really long legal documents, and also compare summary augmented chunking to other chunking techniques or on an end-to-end benchmark. So if you're interested, I am really looking forward to your questions, and here you can find my contact details. Thank you for listening.
Thanks. You stay with us for the questions,
Yes.
and we move on to the last presenter of this subsession. And just okay, you can use this, but we need to share the screen on Zoom because it's not sharing. This one. Oh.
Okay, let me start. Hello, everyone, and thank you for giving me the.
The people online can see your
Okay,
presenter mode.
I will
so
change this. I think this is better. Yep.
Yep. Go.
Yep. Okay. Okay. Hello, everyone. Thank you for giving me the invitation to present our work in NLLP workshop. And today I will introduce COLAG on the fly Korean legal knowledge editing with continuous retrieval. And our goal is to enable large language models to continuously update legal knowledge without full retraining. So in the background, legal knowledge such as law often needs to be revised over time or modified and rippled in response to the social and political issues. For instance, between 2020 and 2022 alone, over 14,000 some legal amendments were proposed in Korea. So this means that like some static language models, even with a well-trained, quickly become outdated in legal knowledge. However, retraining the LLMs every time the law change is almost impossible and costly. So instead, we can apply some knowledge editing methods to selectively update only the necessary parts. But traditional knowledge editing methods like MEND, ROM, GREX, that things tend to be vulnerable to in some environment where legal knowledge is frequently and repeatedly updated. So to address this problem, we propose a COLAG, a sustainable framework that performs on-the-fly legal knowledge updates. So it relies on the knowledge book, which stores some unstructured legal provisions and amendment histories, like from 1970s to 2020s and in Korea legal updates, and to dynamically retrieve the relevant law based on the given legal context. And COLAG integrates some editing-aware learning strategy and the low-edit retrieval, enabling on-the-fly knowledge editing by retrieving the relevant document from the knowledge book and automatically updating the legal knowledge itself. So let's look at the first component, editing-aware learning strategy, which teaches the model to decide whether to edit or not in real time. So we use this kind of loss functions increase the successful editing through the bilinear relational modeling, guiding the model to consider the key and value pairs, relational some consistency during the updates, the above two losses. And the other two losses using the seizures, like using the pinpoint, designed for mitigating the relevant noise, retrievable noise, and preserving the model's capabilities on other downstream tasks and unrelated prior knowledge. Next one is low-added retrieval. So we also propose a new retrieval model that helps the model recognize the subtle differences like timestamp or penalty changes. So we trained on-the-shelf embedding models like BGM3 using contrastive learning to capture fine-grained legal semantics and temporal variations. Incorporating the hard negatives to improve the accuracy of retrieving relevant document from the knowledge book. So COLAG outperforms other state-of-the-art editing methods in the Korean legal domain, while preserving the fast inference speed like that table 2, and compared to other editing methods, and sustaining the high performance even with some retrieval noise are interrupted. It also maintains highly consistent performance in sequential edit, which is the most critical aspect of legal knowledge editing. And the necessity of each component in COLAG was verified through our evaluation study, and more details you can check in our paper. And we also demonstrate that COLAG can be effectively utilized not only for knowledge editing tasks, but also for other legal NLP applications. And we recruited 3 licensed Korean attorneys to expert evaluation. They assessed that result editing using the COLAG were over 55% more accurate compared to other editing methods. And so takeaway. CoLAG enables the real-time and continuous legal knowledge updates, so it achieves state-of-the-art performance while preserving the model stability and linguistic capability. We believe this framework can be extended beyond Korean law to support some multilingual or cross-country legal systems in the future. So if you scan this QR code, you can check our code and data sets. Thank you for listening.
Thanks. Okay, so we have around 15 minutes for questions for all presenters, except I think the GuRE paper, which we lost. So who wants to have the first question? Meanwhile, I will turn the camera so that people online can see us. I thought I handled it. Okay, cool. Okay, who wants to ask something? You want to, Zhang? I have something, but I need to find my notes.
Yeah, thanks a lot for all the great presentations. I'm actually not in the camera. I'm Johnson from Master University, but that's okay. That's okay. They may wonder who's talking. Yeah, so maybe I actually have a question for the last authors. I'm curious about your data set. If possible, I see this beautiful results figure at the end, and I think your proposed methods outperform significantly compared to others. I just wonder, like, is the data set, is it your curated data set, and how does data set being created?
Yeah, our curated data set, firstly, we constructed our data sets almost 30,000 samples for training the CoLAG framework, and we tested 800 single edit and 4,000 sequence added samples. So those are things we created.
I see. Great. And then also the data set is publicly available?
Yeah, publicly available.
Okay, that's great. Yeah, thank you very much. Thank you.
Thanks. Anybody else or? Okay, so I did find my notes. Maybe so I have because this was the session about the sub-session about retrieval and RAG, and I'm also doing some work in retrieval, and maybe this is for the will execution retrieval or the the Marcus and his colleague, because you are doing also retrieval, and I think that I don't remember, so maybe you can remind me now that I think you both experiment a bit with hybrid retrieval, both like trying a bit BM25 and semantic search, and I'm not sure what you concluded and why. So maybe you can reiterate that and what are your findings? Because I think, at least based on our experience, seems that hybrid retrieval seems to work. But I think that, yeah, maybe you have some different findings. So can you elaborate a bit on, yeah, practically, BM25, which is this monster of performance and dense retrieval or combined? Yeah, I don't know who wants to go first, but.
I can go first. Yeah, so we experimented with both BM25 and like semantic search, which is dense retrieval, and then we experimented with also combining both. And that method that we use is like reciprocal rank fusion. And we experiment with two data sets. In both data sets, we found that the hybrid method outperform using individually only lexical search or semantic search. So I'll say hybrid search capture best of both worlds, at least for our cases, like wills and retrieving relevant laws. So they can capture the complementary features which lexical search and semantic search provide.
Thanks.
Yes, I can also go onto this topic. In our presentation, we didn't show any results for the hybrid approach, but we indeed did some testing with hybrid approaches. So we also used the reciprocal rank fusion for sparse and dense retrieval, also with different weights of the combinations of both of them. Yeah, and we found that the sparse retrieval helped us to find the correct document easier, as we showed in our presentation, the one metric where it was about finding the correct document. But when it came then to the text level precision and recall, which is the interesting part for the retrieval because we want to extract the correct text snippet, then the hybrid approach couldn't really persist against the normal dense retrieval. And for this reason, we just throw the sparse retrieval away because it was more overhead and it didn't lead to better results essentially. So we stick to the dense retrieval. Yeah, but more research would be interesting here also.
Okay, cool. I also have one question maybe for Tugba and her work with Oblique Ray, because I think you mentioned that yeah, it's a synthetic data set, right? So I'm wondering, how are you planning to turn it into a real data set? Or maybe you mentioned, I think, something about maybe an expert. So yeah, do you have any
Okay.
concrete future steps or?
In the future step, the main problem is we use a bunch of documents. It is, for instance, how I can say, it is include some accountants department detail, legal department detail, IT department detail. And to combine all this expertise together was difficult. In the next stage, we have a collaboration with a regulatory authority. In the next step, we will provide some question and answer to them, then they will annotate or validate our data. And right now we can call our synthetic data as a silver data set, but next step will be gold data set and it will be available soon.
Okay, thanks. Anybody else from the audience has a question? Now it's your time to speak. I have one more question, but I'm not sure who's it about. Who had the GPT-5 mini experiment?
I had one experiment with GPT-5
Okay.
mini.
Maybe it's for you because sorry, I have like chaotic notes. Let me try to decode my note. Oh yeah, I think that somehow GPT-5 mini, right? They had maybe largest accuracy gains, right, when paired with your hybrid RAG framework.
Yes.
Which was maybe relatively speaking way better than GPT-4o and GPT-5. So what is your takeaway on here? I think maybe you mentioned something or I saw something in the paper, but can you elaborate a bit?
Yeah, so I think for GPT-5 and 4o, the thing can be their bigger model. So there are a chance that they may, because these are the state courts available online, so they may memorize those better than GPT-5 because 5 mini. GPT-5 mini is smaller than 4o and 5. So it can be that maybe GPT-4 and GPT-5 hallucinate a little bit more because they memorized more. So that can be one explanation, I think.
Okay, cool. But yeah, cool finding also. Okay, anybody else wants the last word? Okay, then yeah, let's thank you all. It was also this transition session that people in the US is too late and people in Europe it's too early. So thank you for, yeah, and people in Suzhou have been out for lunch, so it has been a kind of challenge to bring people in this session, but I think it was very helpful and informative. So we are going now to move on to the next session. And I see the presenter is already, the first presenter is going to set up. I'll show you this.
Hello, everyone. My name is Pedro, and today I'll be presenting LaborLex, Portuguese corpus and information extraction pipeline for the Brazilian labor law. This work is co-authored by Nadia, my PhD advisor. So besides the lack of resources and benchmarks for the Portuguese legal domain, this is a relevant work because we provide a pipeline for structuring labor documents, which leverages search tools and jury metrics, bringing greater efficiency to the Brazilian labor courts. And in a labor case, employees get to make claims which are supported by the labor legislation. And these claims can be financially quantified according to the case's facts. So for instance, this employee over here might be owed over 2,000 Brazilian reais due to working in unhealthy work conditions, which is a claim. And he also might be owed 10,000 reais due to moral damages, which is another claim. Then later in the proceedings, the judges get to decide on each claim for the employee or the employer. And for those claims awarded to the employee, they get to set a conviction value as well. Another type of relation that we care about in the second sentence there is the role that people perform in the proceedings. And this is relevant for us because we are able to identify judges, witnesses, legal experts, and so on by processing the documents. In the end, we labeled over 400 legal documents from many different types and produced over 71,000 entities and 15,000 relations. And we used all of them to train all the models in this work here. So for the NER subtask of the pipeline, we experimented with the fine-tuning of BERT and ROBERTA models from both legal and general domain. And we also experimented with using conditional random fields and linear layers as classifiers. And for the NER subtask, the best model we got was a general domain BERT, which yielded us almost 90% F-score using the CRF classifier. As for the relation subtask, we used a pure architecture proposed by Zong and Chen, and we evaluated the fine-tuning of the same ROBERTA and BERT models. And since this is a pipeline approach, we trained on the gold entities, but performed the evaluation on the predictions made by the best NER model we got. So in the end, the best relation model we got was from a legal ROBERTA, which yielded us over 82% F-score. We also did some experiments with LLMs using in-context learning. We picked 3 closed models and 4 open ones. We used a fixed JSON output for them, and experimented with two different prompting strategies. One portraying the task as an annotation, and the other one as question answering. And for the best results we got from in-context learning, the best model was OpenAI's O3 for both subtasks. And as you can see here, the results were quite below the supervised approaches. And the best open model we had was DeepSeek. And most of the errors in the experiments we had here were associated to hallucination, invalid JSON output, and the prediction of spans that didn't match the original text. When doing an analysis of the errors that we got from the NER subtask, we could see that most of the confusions made by the NER model were predicting claims as repercussions and vice versa. We can see an example of this here, in which the model predicted the severance pay claim as a repercussion. And we can see another type of error here, which is a boundary error. The model missed a couple of tokens from the period of stability claim. And as for the relation model, in this sample sentence over here, we have these blue spans corresponds to decision entities, and the two brown ones are claim entities. And we can see here two types of errors that the relation model made, which was missing the decision relation between the intraday interval claim and the dismissed decision. And it also predicted a non-existing decision relation between overtime and reverse the judgment. And here we have a really interesting example in which we have a large paragraph containing all these different highlighted entities there. We have over 120 possible relations between all of them. And for this sample over here, the model predicted all of the relations correctly. So this was really exciting for us. That's it. Thanks.
Thank you. We're taking questions at the end. This is, by the way, the subsession on resources, datasets, and evaluation. And the next presenter is about to set up. I cannot pronounce your name, so or
it's Pawit Sapat, but thank you.
Okay. Thanks.
Oops. Okay. Good afternoon, everyone. Today I'll present our work on aligning LLMs on Thai legal question answering using efficient rewards. This is the sequel of our NyayGraph work, which we presented in the main conference yesterday. So in LegalRack, we've always focused on the retriever, but our NyayGraph work revealed a major flaw that we tested on the golden context scenario by giving the LLM the perfect documents. But even with the 100 accurate information, a massive 40% performance gap remained on complex tasks. This proves the LLM reasoning ability is the real bottleneck. And our challenge is, how do we fix the LLM affordably? Our solution is to directly align the model's behavior using group relative policy optimizations, or GRPO. Instead of just predicting the next word, the model generates multiple answers. We then score these answers with a specialized reward functions that measure what we actually care about, which are the citation accuracy and the response quality. The model then learns to produce the better and more reliable outputs. The key to making this work affordably is the reward design. So the citation accuracy is straightforward to the measure. But the real challenge is judging answer quality. The standard is an expensive LLM-Judge, which is a huge computational fallback. And our main idea was to test a simple, efficient proxy by using a semantic-similarity score from a BGEM3 embedding models. It's more cheaper, but is it good enough? So we'll find out. This led us to three key questions. First, can our cheap reward work as well as the expensive one? The second, do the type-specific models align better? And third, how much better is our direct alignment than the standard tuning? So we tested this on the nitty bench on our both set. The first one is CCL, which came from the corporate and commercial law, with as an in-domain EC cases, and the nitty bench text, which is an official text rulings from the revenue department as a complex out-of-domain cases. And several Quen-based model and compare our GRPO method against the standard baselines. So for the results, on our in-domain benchmark, the answer is a resounding yes. A cheap semantic reward is incredibly effective. And as you can see, it's not giving a strong performance boost over the baseline, but it actually outperforms the expensive LLM-Judge by being significantly cheaper, over 2.5 times in training time and the computational cost. But however, on the much harder complex cases like a text benchmark, we saw a critical trade-off. The cheap semantic reward became unstable. You can notice it in the consistency score, and it actually drops below the baseline. The model learned to sound right without being factually correct. And in contrast, the more nuanced LLM-Judge provide a stable improvement across a board. This shows that for the high-stakes complex reasoning, the signal quality from the judge is worth the cost. For the next research question, we found that the base models prior are crucial. The general purpose model responded well but on in-domain tasks, but its performance collapsed on the out-of-domain task. And for the type-specific model, you can see that they are more restrictive on the alignment in domain and also remain robust on the out-of-domain tasks. This proves that the alignment works best by refining strong existing knowledge from the prior models. And for the last questions, finally, our approach compared to the standard fine-tuning, the difference is huge. By the leverage of the direct optimization with GRPO delivered a more than 90% relative gains in the citation accuracy and a more than 31% increase in the overall answer quality compared to the instruction tuning. And for the qualitative analysis, as we don't have much time, so the qualitatively, we found that the LLM-Judge works better on the hard cases, but it removes the necessary intermediate reasoning steps, preventing the model from taking a flawed logical shortcuts. Okay, so to conclude, our three key takeaways are: the first, efficient rewards works. For specialized in-domain tasks, a cheap semantic proxy is a powerful and cost-effective solution. And the second, the specialized model align better. Starting with a strong domain-aware model is essential for robust performance. And the last key takeaway is that direct alignment is superior. For controlling the fine-grained behavior like citations, GRPO and other reinforcement learning with verifiable rewards provides a massive gains over the standard instruction fine-tuning. So thank you for your attention. More ablation and discussions were in the papers, and below is the nitty bench paper that I presented yesterday. Thank you.
Thanks. And next up is seeing cool, yeah, which is a findings paper at the ClaimGen.
Hi everyone, I am Siying Zhou from Zhejiang University, and I'm today to present our work ClaimGen-CN, a large-scale Chinese data set for legal claim generation. And the existing legal AI, they mostly focus on the help professionals to make the decision like in court tasks, and our focus transfers to help non-professionals and to the pre-court tasks. It's like from the judge to the plaintiffs. And our core contributions are we propose the novel task of legal claim generation and construct the dataset ClaimGen-CN, the first large-scale dataset for this task. And we design two evaluation metrics for this task is factuality and clarity. And that's how we construct the dataset. First, we have the first instance civil judgment documents, and we use sequential inclusion to ensure this task-related segment completeness. And we segmented them and structuring them to return the top 100 most common civil causes of actions like lending and construct and so on. And we selecting the cases only the court fully supports the plaintiff's claims. And this data set is large scale and diverse and plaintiff centered and have comprehensive coverages. And for these two dimensions, factuality and clarity, it means the LLMs should not make up the facts and should have the output remain clear and short and concise. And for all the models, we have zero-shot settings and simple prompt. For the results, we found that DeepSeek R1 has the most high GPT-4o score. And for all the models, there are more place to develop. And we have the error analysis and case study. It says that for example, the Llama and the Claude may made up facts, and the Faray may have generate more information than we need. And for the conclusion and future work, we have the data set and file available in the GitHub and Hugging Face. So feel free to get access to it. And we have this QR code to the repository and to WeChat. Thank you.
Thanks. And then to conclude the round of this sub-sessions, I think we have two virtual presentations from Europe. So both woke up very early. I think the first one is Niels, who's already sharing his screen. So whenever you are ready, you can start.
Yes. Hello. Can people hear me?
Yes.
Okay. Oops. Okay. Can you see this? Can you see my slides? Yes, no?
We can, there is some lag, but yeah, we can see your screen. Yeah, we can see.
Okay, good.
Yeah.
Okay, great. Thanks. So hello, everyone. My name is Niels Holzenberger, and I'm going to tell you about this project that we did with the Catala programming language, together with Gabriele and Aldo. So the starting point for this project is the Catala programming language. So the point of that programming language is that you can take tax law. So at the top of the screen here, you see an extract from the US code, from the Internal Revenue Code. And then you can translate it almost directly into code. So that's what you see here at the bottom. And then the point is that once you've done this with all the sections in the tax code, you can compile all of this into a big expert system that can compute taxes. So the goal for designing this language, which we didn't do, somebody else did, is to produce high quality code for tax expert systems. And the way they did this was by implementing all the good practices from the design of programming languages. Their idea is that the catalog code has to be written by lawyers working together with computer scientists, sort of in a pair programming system. And then in the compiler, they've added lots of tricks to check for super obvious problems like logical contradictions or faulty coverage in rules. So they did everything really well, but they made one mistake, which was to publish laws and their catalog translations that they produced online. And so it was only a matter of time until computer scientists such as myself would try to automate the translation using a large language model. So actually, this is an actual interesting problem because there had been several attempts at doing semantic parsing for legal language in the past. And it turns out that these findings were mostly negative. It's a really difficult task. One of the problems was that there was no sizable dataset. So I'm going to give you the conclusions in case I don't get to the end of this. So in this paper, we produce, as far as we know, the first sizable dataset for code generation from, I should say, legal text, but for the tax law domain. And that's actually relatively similar to semantic parsing of legal text. In that paper, we also have results with proprietary LLMs and open source models. And we reach performance that is, let's say, roughly comparable to at least one other low resource programming language. So this shows that this translation is feasible, but it's mostly a matter of having enough data. There's lots of things that we still want to do after, beyond this paper, but you can ask me about it if you're interested. So looking into the data that we collected. So data comes from a GitHub repository where the authors of Català have published examples of laws translated into Català. This is what one of the files would look like if you opened it. So at the top here, you have the actual extract from tax law. This is section 132 from the US tax code. And then right afterwards, you have the translation into Catalan. So they actually put these quotes around it so that you can neatly separate the legal language from the code. And so they've kept this alignment throughout the files, which was very helpful. Another thing that you'll find in the files is this thing called Catalan metadata. So that is not aligned to any legal text. And it's a bunch of helper functions or helper classes that will be used throughout the rest of the file. So for example, it defines what a person is or other kinds of useful variables. So what we've done is we've decided that both the input part and the metadata fields would be inputs to the LLM, and then the expected output is the actual code, the Català code. And then we've measured performance using a bunch of metrics from code generation. Okay, so here are the results. So at the far left, you have proprietary LLMs used in few-shot learning. So you can see that the performance saturates around 52, 53 blue. And then we've also tried fine-tuning open source models using QLoRa. So here I'm just showing two of the models that we tried. Qwen 2.5, which we consider a general model. And then the same Qwen 2.5, but fine-tuned on a coding task. And so the performance that we get here is substantially higher. So here are some examples, but I'm going to skip them in the interest of time. You can ask me about it if you want. And here for reference, but we're also mentioning this in the paper, is the comparable result in code generation. Okay, and so I'll leave you with this. I'm at Telecom at my university. I'm hiring 2 PhD students and 1 postdoc. So if you're interested, please reach out. And that's it. Thank you very much.
Thanks. We move on to the last presenter for this batch, Leonard, also from Europe, also up early.
Yeah. You can hear me and see the screen?
The sound is a bit like from deep. I don't know how to, yeah.
And it's not getting better, yeah?
Yeah, maybe you can speak up a bit because, yeah, it will increase the bass.
Okay, I will try. Yeah. Okay. Otherwise, hi, I'm Leonard, and I'm presenting the work that Jerry and I did on the linkage of TikTok's terms of service to their moderation actions. So let's look at the problem first. The European Commission mandated that ever since September 2023, very large online platforms, that is, platforms with 45 million or more monthly users, upload statements of reasons for moderation actions to the DSA transparency database. The top 3 platforms are Google Shopping, AliExpress, and Amazon Store, and then follows TikTok with the most statements uploaded as of yet. So why do we look at TikTok? Because the other platforms have highly repetitive statements, so they give out the same statements for all moderation actions. Moderation actions include banning a user or restricting the visibility of the posts and such. And over 200 platforms need to moderate their actions so far. So what we tried is linking these explanations to why the content is incompatible, so these statements of reasons, to terms of service or other legal documents from TikTok specifically. And the problem that we found is that these statements are highly repetitive. So you can see here we looked at a subset which had already 5,000 unique explanations, but the top 10 explanations used covered 85% of all explanations. So to investigate a bit more, what we tried is coming up with a gold standard data set. For that, we used 100 random unique statements and a team of legal researchers, and asked them to link the statements to 124 previously chunked chunks from legal documents of TikTok that included terms of service, community guidelines, ad policies, etc. And what we can see is that the chunk agreement and even more the Cohen's-Kappa score, if we look at that, is incredibly low, which means that even legal experts can, or legal research teams can barely agree. And the task is highly ambiguous. And another finding was that the redress dimension, I forgot to mention that, the research team, they did the gold standard data set, they looked for a linkage. So what is the best chunk? And they also looked at 5 clarity dimensions. We called them to assess a bit the fairness of statements. So is there a possibility of redress given? Is the language clear? Is there a lot of legal terms included? Stuff like that. And the redress option, that was what I was going to mention here, was almost always negative. So in 99 out of 100 cases, it was negative. So this is the overall structure. I'm not going to go through all of it time-wise, but this is all of what we did, and we're focusing here on the linkage and the fairness. So first, for the fairness, we tried to build simple classifiers. And what we can see here already, it's only 4 instead of 5, because as I mentioned, the redress was almost always negative. So building a classification model for that is just not feasible. And even in those scores, you can see that there's suspiciously high F1 scores for some of them. And this is likely due to, of course, a small data set, but also, again, the massive finding here, the incredible vagueness of the statements. And for the model performance, for the linkage itself, we can see that the OpenAI embedding model is the best performing model, which is a gated model, so you have to pay for that. And it's a dense model. And surprisingly, the next two, RBM25 TF, IDF, are sparse models. So what we tried next is to fuse those two. We can see here the orange bars are the fusion models and the blue ones are the individual models. And the best performing models were the hybrid models, so a type of early fusion where you fuse the scores before you rank them and have this alpha parameter, which tells you how much influence the sparse model has on the result. Yeah, So the conclusion in the end was that there's a massive transparency gap between what the European Commission wanted from these statements to produce more fairness and more transparency. And instead, we have highly repetitive and vague statements with information about appeal being almost always absent. Even the human annotators disagree a lot. But if you want to make models to perform the linkage for you, the hybrid models perform best with a 10% increase in MR and 5% in recall. And the fairness assessment might still give viable insights for the users to come. Yep, that's it already. So thank you.
Okay, thanks. Now I'll turn the camera and it's time for questions for all 5 presenters. So who wants to start or who wants to take the first question? I'll come to you, Thales.
Thank you. I have a question to Pedro from LaborLex. I saw that the results for the LLM experiments were significantly worse than the fine-tuned and linear models. So I was just wondering, how was the setup? Because I'm assuming there are many different types of relations, right? So how did you select the examples? And if you can just talk a bit about why do you think the performance was so much worse?
Yeah, we had 4 different types of relations. We were interested in relations around the claim entity. We were interested in finding out the decisions around the claims, the values, and also the matter of the role that people played in the proceedings. And what we did for the in-context learning, we used a few short examples. We had for each of the relations, we had 3 or 4 examples. And we chose these examples based on we performed a clustering on their embedding representations, and we chose the ones closest to 4 different clusters. So we could get examples that were quite different from the other. And we use these to form the prompts. And as I said earlier, we had 2 different prompting strategies. One of them, the one I said was portraying as an annotation, is that I gave a series of instructions to the LLMs, gave the few short examples, and had it sort of labeled the text we provided to them according to the few short examples. And as for the QA strategy, we gave some of the same instructions. We gave the same few short examples, but instead of having it annotate the data, we were asking about the different relations we had. So for instance, what are the entities, what are the terms that determines the decisions based on this text? How were the claims decided? What are the values for each claim? What are the roles that people played according to this text, and so on? And this is what we did in terms of experiments with the in-context learning.
Thanks. Yang?
Thanks for the all great sharing. I have a question specifically for the ClaimGen generation, the author there. Yeah. So I also saw you also did a error analysis for the different models you have been using. So I was just kind of wondering, have you observed that there is any common pattern reflected from each kind of model? And I'm not sure if you also test the different prompt strategy and how will that affect the result? And again, will is there also a similar pattern reflected from the zero shot? And what will be our future improvement for this kind of research? Thank you.
Okay, thank you very much for your question. And for the 6 LLMs, we see some similar patterns. It's like they may made up facts and generate a lot of information that is general and not specific to the case. And for the evaluation, we only adopt the zero shot because in this work, we concentrate on the data set and not the method. So, but for the experiments that is not included for this, in this paper, we have a few shot method before, and we found that it can improve the performance a little, but not so much. And for the future work, we think maybe some SFT or some method may improve the performance of models. And that's it. Thank you.
Thanks. Yeah, Andrea.
Hey, I actually have a question for the last, or Leonard, if I remember correctly. So okay, he can hear, I assume. So you showed that the OpenAI text embedding models perform much better than the open source LegalBERT equivalent. But is a LegalBERT itself an embedding model? Or how do you end up doing the retrieval with the LegalBERT? Because it's striking to have the text embeddings of OpenAI to be that much more performant.
Yeah, it is, and I think the main reason is that what I assumed here was that the LegalBERT model is based on BERT 2, and now the newest version is BERT 3. So I think it's simply the fact that it's an old model that we're comparing against, and therefore even the legal model, which should be trained on legal text, is not that much more performant. And another thing is that the statements are also a very specific kind of legal text, and I guess it just doesn't generalize on the legal text that it was trained on initially or fine-tuned on initially. So,
I see those arguments. I would expect if those arguments were the case for the performance difference to be smaller, but if you test it and that's what it is, I guess so.
I think there was another paper which has similar findings, but yeah, I don't remember now which one, but yeah. Yeah, but also this data set is quite small, so yeah. Is there any other question? Or then I need to check my Scratchpad, which is, yeah.
I have a question to the TaiQ legal question and answering team. So I have two questions. Do you have any criteria to select the reward strategies? That was first one. And second one is any reason to select the low rank adaptation learning to your GRPO? Because, you know, conducting the GRPO learning, there may be more GPU resources needs, but you use the LoRa tuning. So I just wonder about that. Yeah. So do you have any criteria to setting the reward strategies for reward function on your GRPO?
Okay, let me share my slide. Okay, let me answer the second question first. Actually, for the GRPO, we have done all the model training using the low rank adaptations with the rank stabilizer. So from your concern, we have faced it too. We have used the NVIDIA A100 80 GB and it runs out of the RAM quickly. So we set the rollout to 20 to prevent the model from breaking. And from the first question, I'm not sure that you're asking about the how the reward function are initialized. So from in the paper, yeah, we have the two reward types. So the response quality rewards, we will use the coverage and the consistency scores, which will be around which will be normalized between 0 and 1. All of them have the same weights on the reward strategy in the GRPO. And the second one is the citation accuracy rewards. So we have implemented the citation F1 reward that it's straightforward, and we have also implemented the other two rewards, like the format reward that checks the XLM format from the output of the LLM, that if it violates, the other rewards will be set to 0. And the grounded citation rewards to check that the legal citations the LLM produce are in the context before the generation or not, because we need to include this reward to prevent the hallucination of the LLM in the future.
Any other question? We still have some time till the last coffee break. I had one question for Niels, who likes tax law based on previous research published at this at this very workshop. So so my question is a bit more maybe general based on this work. Like, I mean, also given this language specific, right? So is there something about tax law that makes it also maybe more easily, I don't know, codable compared to other domains of law? Or can you maybe share a bit more, also maybe talk a bit about the examples that you asked over?
Yeah. What's different? So tax law is somewhat different from other domains of law. One is that it has lots of rules. There are more regulations in tax law than in other domains. The main reason is that almost everybody pays taxes, and or everyone has to file taxes. So the legislator wants to avoid massive litigation, and so for that reason, they just try to specify everything ahead of time. And the other reason is that, so for AI specifically, pretty much every case in tax law comes down to computing a number, which is the amount of tax that someone owes. And so this makes it much easier to evaluate in general, or you just want to predict a number instead of predicting something more complex like a decision. Yeah, so I can show you one or two of the examples that I skipped over. I think that was your second question. Yeah, so I've essentially one example where it works, one where it doesn't work as well. So this one here is a translation from a French law, which essentially just sets the minimum wage for a certain year in a certain place. And so this is the expected output in Catalan, and this is what the model produces. So it's pretty much the same. You can probably see the difference, except that the ground truth says that the current date has to be strictly before May 1st, and our model predicts that it has to be on or before April 30th. So it's basically semantically equivalent. What's interesting is that the original law does not mention this end date on May 1st, but that's something that the programmers have actually encoded, and our model has learned this from other examples. Here's an example where it doesn't work as well. So this defines an exception to a rule, and within that exception there is another exception. So there's an exception to the exception. So this is the way that the programmers have encoded it. The top part essentially encodes the exception, and then the bottom part encodes the exception to the exception. So it's kind of a two-part thing. And exceptions are usually encoded separately in Catalan. And then what the model produces doesn't look like it at all. I mean, it roughly matches what you would expect, but it doesn't really separate out the exception from the other from the base case, and it also makes other mistakes. So essentially, it hallucinates a date check, misses the exception, and actually the code doesn't compile, but that's just a detail, really.
Okay, cool. Yeah, but it's a cool maybe also benchmark overall. So all these people try these mathematical benchmarks here because it looks a bit like that, but okay. Any last pressing questions? Yeah.
Thank you. For the text work that translate into the Catalan language, I want to know that have you faced problems like the vagueness of the legalese in the text, like maybe it doesn't specify the exact amount of money or like the conditions, like maybe the conditions something like the violate something high enough or low enough or like this. How the question is do you have seen these problems in your experiments, and if you do, how did you handle it?
Okay, yeah. So in the end, this wasn't a problem. The reason is that we're really in a setting where the things are very operational. So the goal is really to compute the amount of tax. So the kinds of stuff that have been translated were regulations that are extremely specific. So there is no vague notions. And in fact, if there is anything vague, like a reasonable cause or something like this, then that's actually offloaded to a human. So the Catalan code will encapsulate it into a variable, which will then be specified by the human. So just to give more context, Catalan assumes that the input to the program is a set of things that the taxpayer declares. So it has access to everything that's on the tax return and nothing else. So this is really made for tax returns and not so much for court litigation. So as a result, things tend to be super specific and straightforward. The problem is doing the actual translation from laws into an executable program. And so that is still somewhat difficult. I think one thing that does relate to your question is that the metadata in Catalan defines a set of helper classes, and that doesn't come out of nowhere, but is not aligned with legal text. So there's some amount of common sense knowledge that's encoded in there. And in one of the examples I showed, for example, there was an end date, which was not mentioned in the text, but which the programmers added because they knew that it should be added.
Thanks. And there is a last question.
Yeah, on the same subject. Have you thought about using an MCP server that give access to the model to a compiler of the code language to be able to do iteration and maybe return something that is more relevant and compilable and can be used after that?
Oh yeah, that's a good point. So that's something we didn't implement, but Catalan has it's a programming language, so it has a fairly strict grammar. So we could have used constrained decoding, for example, just to constrain the output and make sure that the output that the model produces actually compiles. In the end, we didn't do it because we were mostly looking at fine-tuned models, which end up learning the syntax anyway. But yes, that would be a future research area. Yep.
Cool. Let me turn this around. So it's time for the last coffee break. Some again announcements. So as I said, we're still looking for the best presentation award, and I just got the gold leaf certificate that comes with a $500, not now, but in principle. So yeah, you have to stay till the end to see who is gonna take that. It's still not written, so you still have a chance. That's one thing. The other thing is that there are still stickers for the groupies. And the third thing is that I think Shanshan booked us a nice hot pot restaurant. He was sending me messages while we were in the session. I haven't checked them, but follow on Huva to see what we're going to post about the restaurant. And I think that's it. We can go to the coffee break. We start at 4. Maybe the presenters of the last session just also come talk to me like
maybe 10 minutes before so that we check that everything is all right. Otherwise, enjoy your coffee break. Okay.
So from the yesterday's comment.
Okay. Okay, we are back for the last session, which is broken into two sub sessions. The first one features summarization and consolidation, and the second one is about emerging trends and tasks. But yeah, let's start with the first paper. The floor is yours, 5 minutes.
Hey, my name is Injung, and this is a joint work with my colleagues Alexander Hoyle and Johan Hamstra from ETH Zurich and University of Zurich. So in this work, we show how role conditioning LLMs for summarization results in summaries that reflect motivated reasoning, which is a very well documented issue in empirical legal studies, where lawyers tend to actively look for and focus on information that confirms their beliefs. So to start with the motivation behind this work, what a good summary of a given text looks like can often depend on users. So many people are now using LLMs to generate more personalized summaries. But the problem is that there's no standardized way to evaluate how the summaries are substantively different. And this problem, we think, can be particularly interesting in the legal context. So for lawyers, what makes a summary of, say, judicial opinion good often depends on their institutional roles. So because of the adversarial nature of their work, they are trained to interpret texts to fit their needs and incentives, which is reflective of motivated reasoning tendencies. And we have increasing evidence that lawyers are using LLMs to get more personalized summaries. But again, without a standardized way of evaluating how the summaries are different, there could be negative downstream impacts, for example, on shared understanding. So this brings us to our research question. Do LLMs exhibit motivated reasoning when summarizing judicial decisions tailored to different legal stakeholders? And we focus on two dimensions of motivated reasoning. So for fact and reasoning inclusion, we explore whether the summary includes all legally relevant facts and reasoning from the original court decision. And for stakeholder alignment, we see whether for a given stakeholder, the summary includes more favorable facts or reasoning than those that are unfavorable to that stakeholder. So for the data set, we used court opinions from the Swiss Federal Supreme Court, 100 criminal law cases, 100 private law cases, all in German. And we have corresponding summaries generated by LLMs, as well as expert written ones for comparison. We used O1 and Llama models to generate the summaries, and we conditioned the LLMs on for different stakeholders. So for criminal cases, those were judge, prosecutor, defense attorney whose client is in a similar situation as the defendant in the original court case, and a no-role baseline where we don't specify any role when asking LLMs to generate a summary. Similarly, for private cases, those stakeholders are judge, plaintiff attorney, respondent attorney, and no-role baseline. And to evaluation pipeline, we use both LLM-as-a-Judge method and human evaluation. So we first extract key facts and reasoning from the full opinion. Then we classify each extracted fact or reasoning into favorable, unfavorable, or neutral to defense attorney for criminal cases and plaintiff attorney for private cases. Then we check if the extracted fact or reasoning is included in a given summary. And with all this information, we can compute these metrics. So facts and reasoning, inclusion rate, and favorability balance. So for evaluating the facts and reasoning inclusion dimension, for each summary, we calculated the inclusion rate of facts and reasoning. And for facts, we see a clear pattern where summaries for adversarial roles include fewer facts. Reasoning, it varies. Perhaps this reflects the challenges in interpreting what legal reasoning means. And the human evaluation results reflect a very similar trend. And inter-annotator agreement was moderate, which is especially meaningful in the context of in the legal context. And for the stakeholder alignment dimension, we calculated the favorability balance by comparing the inclusion rate of favorable facts or reasoning and the inclusion rate of unfavorable facts or reasoning inclusion, facts or reasoning. And as highlighted here for the criminal cases, defense attorney summaries compared to the opposite side, the prosecutor, the balance is consistently higher across the models. And for private cases, the pattern is similar, but relatively weaker, perhaps reflecting a bit more challenging nature of judging favorability in private law. And this was also reflected in human evaluation results, where for criminal pattern was very clear, while for private cases, the results were a bit more mixed. And again, inter-annotator agreement was pretty good, moderate for criminal and fair for private, and this is meaningful, especially in the legal context. So to conclude, we show that LLMs systematically tailor summaries based on roles, selectively including content in ways consistent with motivated reasoning in law. And our main contributions are twofold. One, we propose a role-aware evaluation framework for legal summarization. And secondly, we show the first empirical evidence of motivated reasoning tendencies in LLMs. Thank you very much.
Yeah, the next one. You need to.
Should I share the screen with this? Okay, hello, my name is Bartosz Ludnikowicz, and I will present you our paper called Domain Adapted Text Summarization with Self-Generated Guidelines. But let's start from what a good summary actually means. So in practice, the answer will be highly dependent on the domain, as we cannot apply the same rules to every type of the summary. For example, abstracts for scientific papers have particular well-defined structure. We all know, I think. The same applies to legal domain. So in case of some civil lawsuits, we need to highlight the facts important to that case. In case of patents, we need to follow the official guidelines, for example, the ones from US Patent and Trademark Office. And given this, we need to adapt our summarizing system to the specific domain. And here are the three most popular methods to do this, each with its own drawbacks. So for model fine-tuning, we need to have access to relatively many examples, which might be just hard, costly to obtain, or take time to create. On top of it, we need some additional computational resources just to train the model itself. When we go to in-context learning, we need significantly less data. We just can start with 1 or 2 examples. However, as these examples can be quite lengthy, it will increase our cost quite significantly. For example, when we use only 2 in-context examples, the cost for input tokens will increase 3 times already. And next, there's of course prompt engineering that doesn't require any data, but it requires some humans with domain expertise and potentially many iterations of and evaluation runs of this prompt. And our aim is to find a cheaper way to do this, the way that requires less resources and can scale to many domains with minimal effort. And here's the summary of our domain adaptation framework. So we only need 2 examples with original text. Can I do this now? So we need the original text, the summary generated by the LLM, and then the gold reference summary. And then we ask the model to identify its previous mistakes and generate short set of guidelines for future inferences. And we save this guidelines for domain, so we only generate it once. And then we just input it in our prompt during each inference. And in our paper, we evaluated our method on 3 different summarization datasets. So multi-lexsum that contains civil lawsuits, a big patent that contains, of course, patents, and archive that contains scientific papers. And we experimented with Gemma-3 family of models, namely 4, 12, and 27 billion ones. And we compared our method with the simple minimal prompt method. So we are just asking LLM for the summary, and with the in-context learning methods with 2 examples. And let's start the analysis with this RUSH scores. So what we can see here that in most of the cases, the guidelines are the third ones in each row. Our summarization generated with guidelines perform the best according to these metrics. What we also find out here and might be interesting is that sometimes when we pass actually in context learning examples, the model performs worse than just compared to the minimal prompt. And our hypothesis is that these lengthy examples possibly act as a haystack here. But of course, we cannot trust RUSH alone as it's far from perfect metric. And thus, we also did the preference evaluation using Claude Sonnet 4. And as we can see here, so the blue bars are the preferred generations used by the guidelines, and the red ones are generations with minimal prompt. For all of the cases except one, the LLM prefers the summarization generated with the guidelines. We also measure the agreement between the RUSH and LLM preference, and the confusion matrices are shown in the slide. There are a lot going on there, but in general, we observed low agreement between those 2 evaluation approaches, with Cohen kappa varying from like minus 0.05 to 0.2. And we also noticed some interesting pattern there, how the preference actually changes when the RUSH or average RUSH score delta differs between those 2 methods. And more details in paper because we don't have much time, but in general, this results highlights the importance, I think, of using the different evaluation metrics and methods instead of relying on only one to obtain some broader picture of the quality of our summaries. Thank you. Check our paper for more details and feel free to discuss it with us anytime. In the paper, we also present the 2 other experiments, one which is the pitfall of this method, when we are kind of unlucky with those initial examples we used to generate the guidelines, and one opportunity to include some final human adjustments in this natural language generations guidelines. Thank you.
Cool. Next one is Max, and
Do you remember how's your file named?
Yeah, NLLP risks. This one, the last one. The NLLP risk limit. Oh, okay.
Use this one if you want.
Can I use here? Or?
Yeah, there are.
Okay.
Good. So hello, everyone. I will talk about our paper Risks and Limits of Automatic Consolidation of Statutes for the German case. This paper was written by Matthias Grabmeier, Niklas Weiß, Adrian Hof, and me, and we are all from the Technical University of Munich. So first of all, why do we need consolidated versions? In Germany, we only have legally binding amendments, but we don't have usually consolidated version except the latest one. So we only have the changes, but we don't have the historical versions of all the laws. And the latest consolidated version might not necessarily be the actual one because the latest change comes out first and is not necessarily incorporated in this consolidated version. And this leads to two problems. So the first problem is that sometimes the courts might use outdated versions of the law. So they might use a law that was in place before, but is not anymore because there's a legal change that is not incorporated in the last version. And the other problem is they might sometimes need historic versions, but don't have them at hand. So for example, in Germany, when you commit a crime, you always need to be sentenced after the more lenient version of the law. So if the law was more lenient at the time of the commitment than it is now, then this law applies and vice versa. So this led to our research question, namely, can large language models to employed to reconstruct consolidated versions from the amendments? So we want to reconstruct the historical ones, and we also want to get the latest version with the latest changes quickly. So we contributed to this that we created a data set with 908 amendments that were then aligned with laws that we downloaded or that someone else downloaded between 2019 and 2025 that contained daily snapshots. And we then conducted experiments where we took the initial version of the law, applied an amendment, and then evaluated against the ground truth of the actual consolidated version. And we also did this like with multiple steps where we took like N laws amendments sequentially and applied them all on the initial version and then compared it to the ground truth after N changes. For the evaluation, we used overlapping and semantic metrics like Rouge and Bleu and BERT score, but much more important in law, especially in German law, is the exact match ratio and the human evaluation scores. So here we see our results for the single step and the multi-step evaluation with respect to the exact match rates. And we did our experiments for the civil code law, the criminal code law, the commercial code, and the Income Tax Act. And while we observed very high Rouge and BERT score for all our experiments, we noticed that the exact match rates are very low. So for the single steps, we had an average of 50%, and for the multi-step, much lower, even 20%. What we then wanted to do is to find out if the imperfect consolidations that are not perfect matches are usable or not. And for that, we randomly sampled 100 imperfect consolidations and gave them to a legal expert to evaluate the cost of how much it would cost to get it right, basically. So we asked him to evaluate this from C0 to C4, where C0 means just a formatting fix, and C4 is like a cascading fix that also affects other laws. So this is a major workover. And even more important, the severity of the flaw, if it would be an actual law. So where we range from S0, which is a typo without legal impact, for example, and S5 would be a conflict with the basic law, so a quite heavy mistake. And we noticed that most of these severity errors are in the range S2, S3, which are intermediate, but definitely substantial flaws. So a real lawyer would not use that. And from this, we derived that high similarity scores does not necessarily lead to legal reliability, and human verification is always essential. So we cannot do it without it. So to wrap up, the exact match rates are far too low to use what we do for practical deployment. The similarity matrices Bleu, Rouge, and Bird score suggest high similarity, but they overestimate the true accuracy of what we get out. For the legal implications, we found out that even small textual deviations can lead to heavy problems in the legal impact. And outputs must be treated as a trust for human verification, and we hope that it can make the process more efficient if they have such a draft before they consolidate the law. What we are currently working on is that when we analyzed our data set for the daily snapshots of the law, we noticed that there are some flaws in there. So sometimes we saw in the metadata an amendment was already applied to the law, but in practice it was not applied. So we were evaluating our results sometimes against the wrong ground truth, and we just want to figure out how to get this better. The second problem is, as we already heard today in another presentation, the PDF extraction from federal the PDF extraction from federal law gazettes is problematic. So we find some cases where we had inaccurate amendment content, and this is of course also a problem. So these are the references, and this research was founded by the German Federal Ministry of the Judiciary within the project Generatives Sprachmodell der Justiz. So that's it. Thank you.
Thanks. And the next one is Luca. Cool. You have your laptop. There's a slight lag, but should be fine.
So hello everyone, my name is Luca. I'm from the University of Bern and the Bern University of Applied Sciences, and I'm happy to present you our work on unlocking legal knowledge, a multilingual dataset for judicial summarization in Switzerland. So first of all, why does summarization matter for legal research? I mean, it matters in many different ways, but here the motivation was that not only in Switzerland, but in many countries, lawyers rely on headnotes to find relevant precedents quickly. And headnotes essentially are summaries of decisions that state why this decision is important. We do have these headnotes for the landmark decisions in Switzerland, so the decisions that are published by the Swiss Federal Supreme Court, but we do not have them for many other decisions. And also, if we wanted to have them, then writing them is very time intensive and it requires expert knowledge. So what we want to do is we want to automate that task so that the judges and clerks do not have to write these headnotes. There are, of course, other summarization datasets, but they are mostly in English, or they are not based on judicial decisions, or they do not reflect a single multilingual jurisdiction like Switzerland. So our goal in this work was to create a cross-lingual dataset of judicial decisions and their headnotes to enable both the training and the evaluation of LLMs to generate headnotes in German, French, and Italian. To do so, we scraped 20,000 anonymized rulings from the Swiss Federal Supreme Court website. They cover 70 years of decisions, and they have a very high compression ratio, so 26:1. The content of this dataset is mainly, I mean, we also have some metadata, but it's mainly the decisions that are either in German, French, or Italian, and the headnotes that come in all three languages. So in total, if you think about it, we have 20,000 decisions and 3 headnotes each, so it's 60,000 samples. And as we show in the paper, they are both a mix of extractive and abstractive summaries. We opted for a temporal split, as you can see here. So most of the decisions are in the training set, We have 1 year for the validation set and 2 years for the test set. And the distribution of the decision languages can be seen below. So mostly German, some French, and 5-ish% Italian decisions. To evaluate how well LLMs perform on this task, we fine-tuned 7 different open source LLMs from 3 different families. And we also evaluated 4 frontier LLMs in a one-shot setting. And to evaluate them, we used both traditional metrics like the overlap metrics rouge and blue, but also BERT score, and then LLM-as-a-Judge to have a more detailed score. We also compare the LLM-as-a-Judge score with human evaluation across 189 head nodes to see how well they correlate. Okay, so for the findings, we see that fine-tuning helps a lot with the lexical similarity, but the models still struggle with legal accuracy, as can be seen by the judge score. We also see that the cross-lingual consistency is not really good yet with the fine-tuned models. So here on this graph, for example, you can see that the monolingual, the scores for German are much better than, for example, for German-French. And French-French is also better than French-German, for example. We see that the head node generation task does not overly benefit from the use of reasoning models in our experiment. So we only used 2 reasoning models here, but as you can see by the highlighted scores, DeepSeek R1 is only 1 point better than Claude 3.5 Sonnet, which is not a reasoning model. And last but not least, I think the most important finding that we had is that you really need to use multiple evaluation metrics to paint a more complete picture, because all of them, they were only correlated in a limited way with human judgment. So our judge score, for example, has a Spearman correlation of 0.26, which is higher than, for example, the BERT score, but still it's not that high. So you really need to consider different metrics that measure different aspects of the generated head nodes. In summary, so we introduced a large-scale data set for cross-lingual legal summarization. We also did a comprehensive benchmark with fine-tuned and frontier LLMs, and we evaluated it using both lexical and semantic metrics. And you can access the models, the data set, the evaluation script, and of course the paper using these QR codes. Thank you so much.
Thank you. And the last presenter of this paper should be online. Cool. Yeah, you can share your screen and start whenever you are ready. He was not ready.
Hello. Yeah, so my name is V. Chera, and I'm going to present the paper Extract, Explain, Abstract, a rhetorical role-driven domain-specific summarization framework for Indian legal documents on behalf of my co-authors, Aditya Gaisas, Avantika Sankhe, and Dr. Narendra Shekhar. So we all know the problem with legal documents are quite lengthy and they're filled with excessive domain-specific jargon, which makes it quite hard to analyze them, and it takes up a lot of time, which is approximately 10% of a lawyer's productivity. And we analyze this from the data set that we use in our experimentation, namely the NAVs and ILC datasets, which have a higher average document length, but a lower number of document count, which makes our task a low resource setting. So small language models tend to perform better in low resource settings, but pertaining to our task, they become untrustworthy due to the longer context length and lower computational power. And namely, the issues we found were text degeneration, which is essentially more collapse, punch, where the model refuses to answer the question, and the most important problem, which is hallucination, where the model assumes facts. And so a question arises, why not just use extractor summarization? Extractor summarization does not solve the problem. There's still a lack of coherency, and the complex terminology is not reduced at all. Which brings me to this. We utilize rhetorical rules, which are certain elements that reoccur in all legal judgment. And these elements are used to assert, justify, refute, exemplify, and conclude in the form of facts, issues, arguments, and so on. And if you observe that there's an actual logical dependency between these rhetorical rules. For example, an argument arises out of an issue. You cannot have an argument without an issue at hand. And an issue arises out of a fact. An argument is always supported by facts, statute, and previous precedents. So we utilize a logical dependency to create a context that can be utilized to reduce hallucinations and improve the information retention in SLMs. Which brings me to our methodology, extract, explain, abstract. Where the first stage is extract, where we segment a document by the rhetorical rules using a domain-specific corpus and TF-IDF. The novelty of our work lies in the explain stage, where we use chain of thought to improve the context. Basically, what we do is we help the SLM guide through the lengthy legal judgment and retain only the critical information. And this explanation is then sent to the abstract stage, where it is condensed into a legally relevant summary. And in our experimentation, we utilize Llama 3.2, 1 billion, 3 billion, 22.5, 7 billion, and 5.4, 14 billion, which is not an SLM, but we utilize it to check the effectiveness of our strategy with a larger model. And the baseline that we use to compare our strategies are EA, which is just extract and abstract, and abstract, which is pure abstraction. So coming to the SLM problem, does a model solve it? Our strategy actually performs better than the baselines across the SAMA-C score, which is for factual consistency. Further, the number of points also reduced, and we actually find this out using semantic similarity using existing funds such as I cannot answer this question or I cannot help you with it. Our strategy also reduces the legal jargon by making our summaries more readable. So we use flesh reading ease and age of acquisition as the metrics. A higher flesh reading ease indicates more readable summaries, and a lower age of acquisition means the words used in the summary are typically learned at a lower age. Do our summaries capture nuance? You can see we use board score and in-legal board score, which is the board variant trained on Indian legal corpus. And you can see the in-legal board score actually is important over here because it shows that it's a better metric than pure board score. But do lawyers like our summaries, which is a really important question that we answered through a human evaluation survey where we recruited 3 lawyers to evaluate our summaries across these parameters. And you can see the EEA summaries were ranked higher according to the parameters. And we also asked them 2 important questions, which were like and replace. Like is a personal endorsement. Do they prefer that summary? And replace is the best possible replacement for the gold standard summary for a particular judgment. And you can observe that our strategies were ranked higher. So in conclusion, we present EEA, which is basically a novel additional explanation stage, which guides the LLM to reduce the amount of hallucinations, making our summaries more factually correct, more readable, and most importantly, legally relevant. Thank you. I would like to thank the NLLP organizers for allowing us to present our work.
Thanks. So it's time for questions to all 5 papers. Who wants to start? Yes, I'm coming.
Thank you to the Max Prior. So yeah, I think thanks to your good some motivations, because as I presented, maybe you can see because my presentation is the previous session. I think our framework COLAC, which is a model editing framework for some legal updates, will be maybe helpful to your some problems from the German some amendments histories, because our method can update on the fly editing method, so we can extract the some historical things, all of the version of the laws, and can update that some legal histories on our context. So maybe you can check our paper. Yeah. A COLAC. Yeah.
So no, for our paper, we have like 2 inputs. We have these PDFs with the changes and the XML with the consolidated versions. And which are your inputs when you create these historical versions?
Yeah, in our project, we just used text-based things only in our using some vector DB. So maybe you can modify it that one. Yeah.
Any more questions? Okay, I need to check my notes. Maybe for the first paper. Yeah. So you define this stakeholder drift bias. Can you maybe, yeah, say a bit more about that? Or, yeah, because I mean, can you say a bit more about, yeah, how you came up with that, and also what does it mean? Or, yeah, why did you have to define a new concept? Or
Yeah, so we defined that because like nowadays, now people, when they prompt LLMs to get more personalized summaries, they probably use explicit prompts, explicitly prompt saying that I need this summary for this purpose, or I am someone and I need this summary, etc. But LLMs are increasingly, they increasingly know more about the users. So even if the user doesn't explicitly prompt like what they need the summary for, etc., the like LLMs can probably assume like already know what the, like, let's say the user is a defense attorney already, so they generate summary according to that. So that's the context where we defined stakeholder drift bias. The stakeholder doesn't have to explicitly prompt, yet LLMs yeah, create that bias.
any more questions? Yeah.
Maybe a follow-up question for the same paper. Is that data set available publicly because it contains criminal law, right? Is the data set publicly available that you created from this?
It's not publicly available. Yeah, but in the paper we do have some examples in the appendix if you want to have a look.
Any more questions? Where are the guidelines, people? Here. You mentioned these bad buts guidelines, right? How did you filter them out, or was it just human the removing, or did you also automate it, or did you think or can be automated? Because I was thinking that, or any thoughts? Yeah.
Maybe show the triangle if you can open it. I'll answer the questions we're both presenting. Basically, the guidelines we're always using were the first that were generated, but we just thought this could come up at some point. So what we call as the bad batch guidelines is just a few generations until we figure out that this seems to be off. So it was asking for explicitation of things it shouldn't have been, or asking for wrong sizes of summaries. So in the follow-up, basically, we checked if Rouge would pick up that these summaries were generated with bad guidelines, and it doesn't. But then that actually gives a lot of support to the LLM preference metric, because it does figure out that these summaries are of subpar quality. And it's a real issue when you are generating natural language guidelines. It can pop up, so a human in the loop can prevent that, or an LLM preference evaluation, even with not another set of guidelines, just a zero-shot prompt seems to pick it up.
Thanks. Any more questions for either of the papers? I have something for Luca. Yeah. Yeah, I think am I making sense? Yeah. So you had this. Initially, you showed this high similarity scores, right? And then you said that they were kind of maybe misleading in the context of legal language. Could you elaborate on why was that? I think I missed it, but yeah. The semantic similarity scores, like high similarity scores, semantic similarity scores. Yeah. Yeah. Or yeah, maybe, my notes are a bit chaotic, but yeah. No, never mind. Yeah. No, never mind. Yeah. Any more questions or? Okay, then we can move to the last 4 papers, which are all on kind of emerging trends and topics. I think the first one is online. Should be Noah, who I saw before online. So whenever you are ready, you can share your screen. Maybe we unshare this screen.
Right. I think you can see my screen, right?
Just a moment, because there was something. It's loading. It takes some time. There is some lag, but yeah, you can start.
All right. Good day, everyone. I'm Noah. Today I'll present our position paper on copyright infringement by large language models in the European Union, together with the co-author Chang Sun. I'll cover the core problem, current approaches, and potential solutions or path forwards. So what's the general problem? We argue there's a fundamental mismatch between copyright law and LLM development. Corporate law relies on generally qualitative standards like substantial similarity or external factors like market harm. These are evaluated effectively by courts for individual cases or on a case-by-case study. LLM development uses quantitative metrics like Rouge, generally optimized automatically across petabytes of data. So these systems kind of speak completely different languages. Technical safeguards alone might not demonstrate legal compliance. We are already seeing this in practice, or at least implications in practice. For example, recent research has demonstrated that Meta's Llama could reproduce chapters from the Harry Potter books almost word for word with minimal prompting. Let's now take a look at the current legal and technical frameworks. So the two core aspects in the European framework are the directive and copyright in the digital single market and the AI Act, where we identified practical gaps. Firstly, there is ambiguity in practice in certain terms, such as lawful access. Does this require following terms of service? Can contracts override statutory exceptions? It's not necessarily clear. Secondly, there's a lack of opt-out standards. There's no single legal machine readable format. Robot.txt, meta text, and terms of service all coexist, making automated compliant brittle. Thirdly, we have sufficiently detailed transparency that isn't defined operationally. On the technical side, safeguards struggle with non-natural similarity like style appropriation or plot reuse. Models are generally opaque, or big models are generally opaque, so you can't prove what was in training if you use it for fine-tuning, for example. And metrics like Rouge don't necessarily map to legal concepts like market harm, substantial similarity, or even prior legal case rulings. This gap is that technical metrics measure different things than basically what legal standards actually require you to do. Let's take a look at the prominent technical approaches that we evaluated. So we examined several technical approaches and identified some key findings for each one of them. Firstly, we have provenance first governance. This provides a good input side control through clean corpora and license tracking, but the finding is that there's generally legal ambiguity that still persists because there's no standardized infrastructure for opt-outs. So you don't necessarily know when something is actually legally gathered. Secondly is the usage of machine unlearning. This basically enables you to post train removal of content, so forget content after the fact. Our finding here is that current methods are vulnerable to model degradation, adversarial attacks, and they generally only address literal copying and not the broader forms of similarity. Thirdly, we have clean chain synthetic data. This offers real compliance by design potential, but our finding is that coverage remains limited by the availability of lawful seed data, especially for specialized domains. So what's our overall finding? These approaches are necessary. They're important building blocks, but they're inefficient, insufficient on the findings or on their own to bridge the gap between technical implementation and legal compliance. So this brings us to the proposed path forward, which is that we need legal technical design across the three layers. Firstly, at the policy layer, we need standardized opt-out schemas that machines can actually parse while being legally compliant. Clarified legal terms like lawful access in operational language, and potentially a centralized registry where rights holders can register their preference. At the technical layer, developers should build provenance infrastructure to track data origins, implement adversarially robust unlearning that can be easily bypassed and forgets more than just literal copying, and use clean chain synthetic data to expand training sets lawfully. At the research layer, we need legally informed benchmark that tests for things like substantial similarity, not just literal copying. We need certified unlearning methods with formal guarantees and compliance evidence standards that courts can try to utilize. The key insights are that all these layers already exist and they have been emerging, but they're working with misaligned goals. What we need is to align them into a coherent auditable framework. We think this integrated approach is essential to making copyright compliance work in basically the age of LLMs. Thank you for listening, and we'd gladly answer any questions during the Q&A.
Thanks. You stay for us with the Q&A, I assume, and the next one is Chang. Cool. Yes. Is this PowerPoint? Yeah. Oh, yeah, I need to. Yeah. Yes. Yeah, go
Yeah,
on.
okay.
Check it in.
Okay, great. Hello, everyone. My name is Chang Sun. I'm assistant professor from Master University. I know it's the end of the day, so I will try to make it very understandable, and at least you learn something in this upcoming 5 minutes. So this work is actually from one of my master students, and there's a collaboration with SURF. It's a Dutch research computational organization. So we are lucky to have the power to run all the experiments. Let me click. Okay, yeah. So as we know that all or most of the LLMs are trained on the web data. It's a large scale of data. And of course, they are actually trained on the public data, we hope, publicly and with license that they train it on their own data, on their own language models. However, there's inevitably that there are some personal information on the web. Well, officially, yes, you public that data is on the web, but it doesn't mean that you want your data always in the model that being used by the other billions of users. And as we know that LLM has the capability to memorize a lot of information, that including your personal information. And for example, in EU, what we have, for example, with the GDPR, we have a right, our data can be removed, meaning that we have a right to be forgotten, which is difficult with those largely trained language models and expensive. And even with, machine learning models, it's impossible if some, for example, subject saying that I want to remove my data, can you retrain the whole machine learning model? And then we know that LLM will not do that if you say, I want to remove my personal model from your trained huge LLMs. And also, the R studies actually prove that those language models can be, let's say, violent by using a simple, let's say, promptings. So if they try to prompt to steal some personal information, that has been proved that is possible. Although, as the previous presenter already mentioned, we have one of the solutions is called machine unlearning. So basically make your language models forget specific information without retraining the whole language models. Yesterday, I had this conversation with my husband to explain him what is machine unlearning, because like he said, well, if your model has been trained on the data, how is it possible to be removed? And then I give an example that I hope is understandable, is that if I want him to forget my phone number, what I would do is I will save my phone number in his phone and then label my contact as wife, for example. So every time when he wants to call me, he would just search wife and call me. So he will not see the number for, let's say, a couple of months. And then he will probably, likely, he will forget my number because his memory is not triggering my number anymore. He's not seeing this number for so long. Then this information will lost in his memory. That is the forgetting part, but then the specific part is also important because I want him to forget my phone number rather than forgetting he has a wife. So this scope, how much you want language model to forget, particularly or in a large scope. In the current existing methods, there are some gaps. For example, the existing methods are focusing on general knowledge, not particularly focusing on personally identifiable information. Second, also the lack of comprehensive evaluation frameworks to evaluate the quality after forgetting this personally identifiable informations. And then also it's
very different when we talk about explicit and implicit forgetting. I also give an example of a figure that just to show you the red star is a question that we want to, information that we want to forget. And then as you can see around it, you have, for example, rephrase the questions, but you also have the questions that indirect to that information. So for example, if you want to ask me, where do I live? You can also ask me, where do your partner lives? Are you living together, right? So you could have eventually get a true information by asking multiple questions. And there's a logic and reasoning behind this. And to solve these challenges in our work, what we did, we first extend an existing word called Permian, and we make the existing model become a model agnostic. So meaning that it doesn't matter what language model that we want to use, the methods can be applied in most of language models. Second is that we make it more efficient, meaning as you can see that the original Permian methods is quite expensive when you run it because the way how they procure the input. What we did is that we focus on the tokens level. So we changed the input of the language models and to make it more efficient. And lastly is also we're focusing on implicit and explicit targeted knowledge. Make sure that also implicitly you can forget certain level of the PIs. Second, we also built a benchmark, evaluation benchmark, that focusing on 16 different PII types: phone number, name, address, bank account, and your jobs, all kinds of informations. We also measuring both explicit and implicit PIs. So on our experiments, what we did is that we generate a data set, and those data sets are for example, the QA pairs. And then they focusing on different QAs, direct, indirect. As we can see that we want to test the explicit and implicit knowledge. And then we separate the data set into a forget set and then test retain set, meaning that you want to forget 10% and then you leave the 90% there. The reason is that you don't want LLMs forget everything, so it becomes useless. And then we put it in the unlearning LLMs, and then we test it to see whether after unlearned LLMs can still answer the questions. So basically to test whether it forgets what it should forget and whether it remembers what it should remember. At the end, we actually compared our model with another 12 different models. These 12 different models are based on the different structures. So they're not significantly different, but it's like mainly 4 different types, but then with the different variations. We used the Llama 2 and 3 and Queen 2.5 with different model sizes. Just quickly show you some results I want to highlight here. As you can see that Permian token and Permian perform definitely outperforming other models. And I want to indicate the inverted, that QA is particularly for implicit knowledge. So that part we significantly outperform the original Permian, and then the model utility we achieve also very comparable with the Permian and definitely outperform the other models. And also we observe the different size of language models. We tested in Queen 2.5, and then we observe that the larger model size can actually better forget PIs. Probably it's because they can separate knowledge better. Interestingly, we also look into the different type of PIs. So for example, we have a general that's about the person, for example, including Twitter username, occupation, home address, and then we have a banking information about bank account, bank name, credit cards, and medical about disease or treatments. And the blue ones are the things that they should remember. So you want it to be 100% remember all of them. And then the red one is the ones that should forget, but then you still see the percentage, they should not be there. So they should forget everything, and you should have the 0 red in the picture. And to view it clearly, then you can see that, the occupation, disease, and treatments are the most ones difficult to forget, let's say. And we hypothesis is that they are they have rich semantic meanings, meaning that it's hard to completely forget about this information. I give example, for example, a person, a phone number, then what you can learn from this person. Okay, that person's phone number, and then maybe the geographic location. However, if you know a job of that person, for example, if the person is a software developer, you probably learn a lot about, like, for example, the person's has a technical levels, a certain education levels, and then the job, the income, those information are hiddenly in those information. So that makes those type of PIIs richer than the others. So they're difficult to completely forget it. So just for the key findings of our work, as our model agnostic machine learning model significantly reduce the PII leakage without expensive model retraining. Secondly, is that we show that different PII categories achieve different level of being forgotten. So the PIIs with richer semantic content tend to be more resistant to removal. And we also observe a scaling effect in different model sizes. That's something that we need to continue looking into in the future work to verify whether that's the true or is only on the Queen models. Lastly is we also create an evaluation framework that particularly for PII and learning. And it's also very important towards the practical appliance with the legal obligations to make sure that those things are matters legally. Otherwise, we just removing removing any information doesn't make really much sense. So we want to apply with, for example, GDPRs or particular national laws. Yeah, thank you very much. Happy to take questions later.
Thank you. Two more to go.
The first one, I guess?
Yeah.
Yes.
Yes. Do you need the notes or
How? I don't have any notes. Is that a bit laggy? So maybe I use this. Yeah. Okay. Yes, second to the last. We are getting there, everybody. Hao Yang, I'm from Wuchang University, a PhD candidate. And it's a long day. I think everybody is getting tired. I hope my topic is still can entertain a little bit longer. And today I'm going to share the work about evaluating LLM-generated legal explanation for regulatory compliance in social media influencer marketing. So influencer marketing is currently a very popular and powerful marketing strategy. It's basically like the brands or like individual entrepreneurs trying to hire those very active and socially impactful person from social media and trying to endorse or affiliate their product with them. So this type of advertisement is super powerful because it's kind of build a parasocial relationship that consumer can be shaped their decisions, their purchase behavior unconsciously. And so it's very popularly used. It's powerful, but it's also very risky. That's why it's really important to enforce the consumer protection law even here. But one of the major challenges, this type of marketing strategy is very difficult to detect, not necessarily for a machine, but even for human beings. For example, here's one example of what influencer marketing looks like. Here you can see there's basically one influencer trying to list all of the possible products about cosmetics listed on the world and to just display it to everybody. And here, maybe for like some people, like you may notice this as an advertisement. Maybe for some people, they will just recognize it as a very organic, normal live sharing post. And in reality, maybe maybe only some of the products is being sponsored and some are not. But we cannot sure until we find a physical paper contract from the influencer, between the influencer and the sponsors, which is impossible for daily users as well as for the regulators. So normally, when regulator trying to monitor or moderate this kind of content, there was basically this kind of a pipeline they need to follow. There was like a hot law, a legal standard will set up different legislation, but they wouldn't tell you what specifically you need to do to disclose your advertisement properly. And then it comes a regulatory organization. They try to interpret the hot law, set up some standard for the industry so that the stakeholders inside of it can at least have some rules to follow. And here comes the content moderator. They can go back to refer to the soft law and then make the moderation more effective and efficient. So here's one case of what is the daily life for those kind of content moderators. Sometimes, like the influencers, when they receive a ticket from the monitoring, either it's a bureaucracy or it's the self-regulatory organization, they might be not happy with their decision because they do think like they don't get sponsored, or maybe they're just trying to stay away from the possible difficulties or challenges. And then you have to, like the regulators need to justify their decision in very strict legal reasoning format. Here you can see maybe here the chairman judgment, like they need to set possible articles and telling influencers which specific article they violated, so that we believe that was really a violation of the rule. And this kind of content is really piling up and create quite a lot of challenges for regulators to finish their job. So here it comes LLM, because it at least people believe it has such opportunity to understand, to at least read and trying to see what is going on in there. And hopefully they can automate the process, or at least just to trying to facilitate to the least cases. So that's basically research background and the aim I just mentioned. And to evaluate their capacity, we try to design this kind of experiment. We first collect data sets, include 3 types of data: disclosed advertisement, hidden advertisement, and organic advertisement. So the disclosed advertisement is sort of a gold standard because we follow our affiliated partner. Dutch advertising, the Statute reclaimer code. They set up the standard, and we try to collect the data set from Instagram, who have strictly followed the ways they require the people to do. So we kind of call this kind of standard as a legal standard. And then we also ask the annotators to annotate like the fair similar amount of post. So we can also find the hidden advertisement and organic content. Our hypothesis is like these contents will be intrinsically different, and large language model will also behave differently accordingly. And then we select the different models, which just the very recent one and free to cheap to use, because this is just a small scale data set, GPT-5 and Gemini-5. And we also test a different prompt strategy. The prompt strategy we equip is the first one, zero shot. It only include the task instruction rather than anything else. And the second one, we involve the regulation specifically, like each articles, relevant articles. We put it in one document and throw everything in the LLMs, and hopefully it can find which part is relevant for the head advertisement. And the third one is we also adding more explanations on some very tricky terms. And then now we come how to evaluate the result they provide. The evaluation task, we also make it two-folded. The first one is the classic accuracy judgment. It's involved precision recall and F1. And the second one is the qualitative. This one we also say is one very important contribution from our work, because we define an error taxonomy, like in this legal reasoning explanation generated by the LLM. And to the best of our knowledge, even though there's some already error taxonomy exists in legal NLP domain, But I think at least in consumer domain, and more specifically in this social media consumer protection domain, we are the first one to do this kind of content. And we have a huge table, so it's impossible to put everything here. And also due to the time constraint, I wouldn't talk too much about our result. But we trying to map all of these different evaluation metrics back to the type of content, back to the model selection, and also the prompt strategy. In short, one takeaway I can give you is like the more prompt, the more information included in a prompt doesn't guarantee the detection result. And sometimes it's actually the zero shot one actually perform the best on the detection task. And it's a quite disappointing fact to see that happen actually. And we also couldn't find any consistent pattern exist on different types of error existing in the models and the prompt strategy. So that could also be one future direction to see, to map these things happening. Okay, so we got the full tables and full findings in our paper. Or if you got any question, I'm also really happy to answer. Like you can find me later. Yeah, thank you.
Thank you. And the last paper, it's a findings paper, which is going to close the day. Overrated, I'm not so sure. Yeah. I'll use this one if you want.
Hello, everyone. I'll be presenting the last session for the day. I know everyone is tired, so I'll try to keep it very short and sweet. So I'll be discussing regarding instilling fair use properties in LLMs, which we found to be something that is fairly under-discussed in the LLM community. So LLMs train on a vast amount of internet data, and as a result, at times, as you can see here, Llama 370B can give us verbatim copies of Harry Potter chapter by chapter. And similarly, models like Claude can overprotect in some cases, where we ask for verbatim copies of A Tale of Two Cities and it rejects our request. However, Tale of Two Cities was previously copyrighted. It recently came into public domain, and as a result, this is now invalid. So the question sort of arises, like, how can we have copyright protection while making sure things that come into public domain are no longer guarded by the guardrails in LLMs? And similarly, LLMs have raised significant copyright litigation, for example, New York Times versus Microsoft and others. So two of the hallmark papers in the field are Memfree and Shield. However, we notice some significant shortcomings of them. Mainly, Memfree tends to hallucinate a lot. The red sections you see in the first box are hallucinations, while the purple sections are verbatim copies. So as you can see, it introduces a lot of hallucinations, which degrades the model performance. And at the same time, the current state-of-the-art Shield tends to outright reject a user's question. And as a result, it really harms the model's utility. Also, both of these works assume that copyright is an issue of verbatim copying, whereas verbatim copying is not a realistic setting. Copyright infringement is way more nuanced than that. For example, I get inspired by someone's song and I accidentally recreate a very similar style, well, then they can sue us in court, right? So verbatim copying is not always the case. And as a result, we need to put more effort into researching that. So we came up with 9 types of copyright infringement based on the modus operandi of text-to-text generative platforms with the help of a panel of US intellectual property rights lawyers. So in the interest of time, I won't explain all of them. The titles are very self-explanatory. I'll just quickly go through them. The first is alternative costs, where we ask someone to replace the cost of a protected universe. For example, Lord of the Rings here. Another is alternative endings. We might ask for a new ending to a particular copyrighted work. Code replication or reverse engineering. Combination of multiple protected universes and copyrighted works. Fan fictions of copyrighted works. Unauthorized translations. Stylistic imitations. Detailed summaries which can act as a replacement or a market substitute for a particular copyrighted work. And finally, verbatim excerpts. Now, once we have sort of come across the nuanced types of infringement, something that also comes on the question is the evaluation metrics used by papers. So the previous papers, as they were very focused on verbatim, looked at lexical overlap metrics like LCS and Rogue, which only work for verbatim copies of text, but not for nuanced types. For example, if I ask for a Taylor Swift song in Bruno Mars's style, well, you won't really have a huge LCS, but maybe the style of Taylor Swift, the essence that makes it her song might be copied over. And as a result, the evaluations are flawed. Similarly, they really depend on refusal rate for a lot of the works, which is like, if the model refuses all the requests, then the utility is harmed. So what's the value in that? And as a result, we really question the evaluation metrics used by these works. So the intention sort of naturally comes out, can we teach an LLM fair use? If the responses are always fair use, then whether it is copyrighted or not doesn't matter, because the answer is transformative in nature. So here's a small example from our work. On the top right-hand side, you can see the prompt. I'm writing a fanfic of Taylor Swift's song. Can you create a new bridge which has the same continuity? And the annotation here is done by our expert lawyer panel, where they said that Llama 3, the base model, gave a response which is very aligned with Taylor Swift's style. And as a result, it infringed on her intellectual property rights. Whereas Shield, which is the current CUDA, outright rejected the request. Our method, LawLM, however, gives a much more nuanced answer. It doesn't give you the bridge right away. However, it tells you how to build a bridge which is similar to hers. So as a result, we are within the bounds of legal generation. However, we are not infringing on the artist's rights. So to create the method, we first had to come up with the data set. And as a result, we had to scrape the US fair use code proceeding data, which is publicly available. And we had a human-in-the-loop pipeline to clean up the data because those were PDF files, and we had to run a lot of post-processing stuff. So in the interest of space, once again, I had to cut out some of the steps, and I'll quickly go through them. So once the 9 taxonomies of copyright infringement was defined, we had the panel generate some seed examples for each of the types. For example, if it's a combination of 2 copyrighted works, we asked the panel to create certain prompts which can elicit that type. And once they created their prompts, it was fed to GPT-4o for synthetic expansion. And those prompts then went through the panel once again for iterative refinement, filtering out useless generations, and also ensuring that we have high inter-annotator agreement. Once the prompts were generated, we once again filtered out some of the sets to ensure that all of the prompts are very high quality in nature. So we ended up with 9,000 prompts, 1,000 per type, which then we perform inference on. For the inference stage, we take a base LLM. So for example, we can assume we have used Quen here. We can take Quen and perform SFT on the judicial precedents that we got from the scraping process. And so this time we do an inference from both the base LLM and the SFT LLM, and then we get a preference data set. Now, this data set, once again, goes to our IP law expert panel to make sure that the annotation is accurate and that the responses are fair use aligned. So once that is done, we thought, well, can we just put it in an agentic setup and does it work? Turns out it does. So what we did, once the prompt goes through, it goes through a topic extraction agent where we got potential copyrighted works. Once the works are extracted, they go through an internet verifier parallelly in nature. So if it's multiple copyrighted works, we do multiple calls to an LLM parallelly, which then tells us whether it is copyrighted or not. If it is, it goes to the base model. If not, it goes through our the fine-tuned model on DPO. So to test our method, we also created evaluation metrics, which once again, for the sake of time, I'll quickly skip through. We can discuss it offline. And here are some of the results. So as you can see, across the board, our method LLM has the highest utility and C8 scores, whereas our LCS is slightly worse, and that is because under fair use, you are allowed to use verbatim excerpts as long as it is transformative in nature. And hence, you'll see that our LCS and ROGUE scores are slightly worse than the other methods. This is the scores across all the types of infringement. And this is the difference, the drop-in score between our trained method and the base model itself. And as you can see, we have minimal degradation. So we are not hurting the model's performance while being high in utility and low in copyright infringement. And this is the human rating of our method for all of the types of copyright infringement. And as you can see, our 75th percentile is extremely high. All the annotators agreed that we had a high utility amount with a low amount of infringement through our method. Thank you for your time. I hope it was short and sweet, and please enjoy your day.
Thanks. We have some time for some short questions for whoever is brave enough to ask a question at this time. Yeah.
I'll keep it short for the last presentation. You mentioned that you need to identify when to use a standard language model or your tweaked one. Couldn't you just replace that component with just the shield component, and whenever it refuses, then you go back? Because then you're utilizing the extensive training it has, right?
Yeah, or you can take the mic, or you can use this mic, but yeah, we have usually that mic, but yeah, this is fine as well. Sure.
Yeah, could you repeat your question real quick?
So you have a component to decide if you're going to use a new LLM or not.
Right.
Can't you just use the shield version, and then if it refuses, then use a...
So shield has two methods. One is an n-gram-based method on a static data set. That is prone to breaking because, let's say, an author passed away. So for US, it's 75 years since the author's death. If tomorrow is the day that 75 years have passed, then the work is in public domain tomorrow. So the static data set doesn't really work in that scenario to be like very dynamic in nature. And the agentic setup of Shield is exactly what we have. It's just an internet call, a web call, which verifies whether it is copyrighted or not, and then goes through the Shield method. So it's essentially the same segment, but with a different model. I hope that answered your question.
Any other questions for any of the papers? Yes.
Thank you for the machine learning paper. I want to know that for after like unlearn the personal information from the LLM, how many downstream legal tasks in NLP did you test these models on, and how was the results? Is it like better, or is it on par or not?
Yeah, thanks for the questions. Actually, we didn't report that because we haven't complete a systematic evaluation on that. But then we had some cherry picking experiments that for some, for example, that if you contract as an input to see whether, for example, you have a contract from a company and you want to use a template rather than reviewing any information about the company. So in this case, it's like the personal information that come from the person, but it could be also from the company. In that case, we look into, for example, the name, the address, and also like the ID part that perform really well. So you can unlearn that very well. Also retaining the memory of the actual things. But then as I mentioned that, for example, if we are talking about like more the concepts with richer semantic meanings, then that's not completely forgotten, but we haven't done a systematic evaluation on that. Yeah, thank you.
Anybody else? No? Okay. Okay, it's like I didn't plan for it. Okay. Let me just reshare a bit my screen. I won't keep it long. Just need to. That's easier said than done. Yeah, I don't even look good. Okay, I made it. Yeah, so it's been a long day, and it's also been streamed, and probably it's going to be streamed until Daniel wakes up in the US to shut down the stream. So it might be like an endless stream. But like everything going to be online out the YouTube channel, so you can go back and see what you said or what your colleague said and watch it when you are bored. Also, as I said, we are also on all social media platforms, so feel free to follow us for staying in contact and join the Slack channel. It's also on our website. There is a direct link, so make sure you stay in touch with the community. That being said, I was scrambling what Shang was posting on Huva, and I did a good job given that I did it in the last 5 seconds. So we're all going for dinner. It's the Cuckoo Hot Pot at 7:30 with a very nice visual. And this is the address. The reservation is under the name of Shang Hu, EMNLP. And clear instructions. I would say join the Huva group in case there might be some last minute things to check. But yeah, I hope to see many of you there. What else? Yes, so there is the big announcement of the day, which comes with a drum roll. So after back end and background deliberations between different organization members and extensive list of at least 150 criteria, the best presentation award for this year, which comes with $500 monetary award, goes to Shuang Liu, who presented the ContractEval benchmarking LLMs for close-level legalist identification commercial contracts. She also must be sleeping, given that she was presenting in the US time zone. So I guess, yeah, she will wake up to some very good news and also get the gold list certificate. If you remember, she was also the lawyer that presented, now doing the computer science degree. And I think that will be all. So we conclude the 7th version of the workshop.
Some of you asked me already if there's going to be an 8th version of the workshop, and we plan to submit the workshop call when the call is out for next year's EMNLP in Budapest. So there is going to be a call soon, because just yesterday we learned it's going to be in Budapest, and we were going to apply for a workshop to be held with EMNLP next year in Budapest. The days are end of October. So stay tuned through our all relevant channels, and hopefully see many of you latest next year in Singapore, provided as in Budapest, sorry, not in Singapore, provided that the workshop is approved. Thank you all, and hopefully see many of you at the